Right, I think it's 10:01. We've got lots of people here. This is super exciting. So I think we might get started. So it's my next slide. Thank you everyone for joining. This is super exciting. Rika and I are both very excited to have you here. Before we get started, I'd like to acknowledge the traditional owners of the land and all elders past and present. I'm currently on Wurundjeri land of the Kulin Nation. Encourage you to reflect on the Indigenous land that you're on today as well while we're here for this lecture. So just some sort of housekeeping before we get started. So we're using Zoom today, which is super exciting for our lecture. So we've got the Zoom chat open so you can message Rika or I, the panelists, for any sort of immediate issues like tech difficulties. If you can't hear me, you need to let us know something. Otherwise, we're going to be using Mentimeter today, which some of you might already be familiar with, which is a really great platform where you can ask questions throughout the presentation that we can answer later on. So here's the code. So if you go to www.menti.com and enter this code 58119017, that's on there. And we've put it on the bottom of every slide so you can come back to it whenever you'd like, whether it's in another window or if you've got another device that you can ask us any questions you think of as you go, and we'll be using it for some fun activities as well. So if you could head over to that now, I'll give you a few seconds to get that ready. So yeah, just as a reminder, yeah, thanks Rika for that. Menti.com, if you enter the code, that's what we'll be using today for any questions that you've got and some activities in a minute as well. Okay, so I'm going to head over to the next slide, but it's going to be at the bottom of the presentation if you need it at any point. So I'm just going to introduce myself. I'll be the lead tutor today for legal studies. So my name's Molly. I graduated VCE from PCW 2018, so almost 3 years ago now, which has gone by very quickly. I'm super excited to be here today to run through the legal presentation. So I'm currently at Melbourne Uni studying, my third year of Bachelor of Arts with a double major in history and English and theatre studies. I've also done 1 semester of a law degree right out of high school, so a bit of experience studying law as well, but I do love my history and English and some other fun things like reading, and I love music and films as well. So that's a bit about me. Rika, did you want to introduce yourself today?
Sure. Good morning, everyone. We're so excited to have you here. I think there's about more than 70 of you here, so good to have you. My name is Rika. I'm currently studying law and commerce at Deakin University, and I graduated from the Skyline program and also my high school in 2019, so 2 years ago. If you have any questions at all, feel free to pop on Mentimeter, or for any urgent questions, use the chat and we will always be here to help you. And thank you. We hope you enjoy the day.
Awesome. Thanks, Rika. Okay, so before we get started, a bit about Skyline Hatch that some of you might be familiar with, but Skyline Hatch is an amazing company that offers weekly tutoring classes and VCE preparation classes, and with some cool upcoming programs like this exam revision series and programs such as Stress Hack as well that will help you get your cool on before the exam as well to help you get prepared. So led by recent graduates from VCE and from Skyline program as well, with group and one-on-one tutoring as well. Also, before we begin, I would love to give our thanks to UBS, who's helped make this exam revision series possible. They've had incredible support, and it's thanks to UBS that Skyline's able to run this revision series this year. So big thank you to UBS as well. Okay, so before we get started with content, because we've got a lot of content to get through today, but Rika and I just wanted to sort of see how you guys are feeling in regards to your confidence in terms of legal. So everyone will be a little bit different. So if you're not already, hop over onto Mentimeter with this same code. And I'm just going to switch over to Mentimeter, if you give me 1 second to do that. And I'm just going to share our presentation. Sorry, give me 1 moment. And present. Okay, so I think this should be working now, maybe Rika, if it's not, let me know, but to let us know, awesome, people are entering it. So how confident you feel about the legal exam. So still got a little while to go, another month or two, but hopefully today you'll be feeling much more confident after the exam. So we've got everyone about in the middle, which isn't too bad. So in between I know nothing and I am a pro. So I don't expect any of you to be a pro yet. That's why you're here. We can try to help you feel a lot more confident, but cool. So we've got, I think, a few different responses, but sitting around a 5 or a 6, hopefully that you'll be feeling more confident after today. Awesome. Just going to get out of Mentimeter, but again, just a reminder, you can use Mentimeter at any time to ask us any questions at all that you have, and we'll come back to them to answer them. Okay, so this is our agenda for today. So we've got a lot to get through, but I'm super excited, and again, hope that will help you feel confident towards your legal exam. So our first part, we're going to have 3 different chunks. So the first part today, we're going to be going through Unit 3, so criminal and civil law. Then we're going to have a 10-minute break. We make sure we give you guys 2 breaks because I know Zoom can be a little bit tiring sometimes, but we're going to have a fun time together. So 10-minute break. Part 2, we'll go through more content. So a lot of the Unit 4 content, another break, and then we'll finish off the content and make sure we've got a lot of time for Rakaya and I to give you some exam tips and to have a look at some practice questions, because application is also super important. Okay, let's get into the content though. So reminder, Mentimeter is there. I've got it at the bottom of every slide. So if you think of questions as you go, do start to ask them. And towards the end of each section of today's lecture, we'll go through your questions and make sure we can answer as many of them as we can. Okay, so to start off, we're going to go through criminal law. So we've got a lot of content today, but I'm confident we'll get through it. And again, any questions, put them through at Mentimeter. So the principles of justice is super important for legal studies, that I'm sure you remember from your class week, that it comes up nearly the whole way throughout Unit 3, maybe not so much the past few months as you've been working on Unit 4, but it's a really good foundation to have to make sure that you're confident in not only explaining, your definitions and understanding the basics of stuff, but you can link it to how the principles of justice are achieved in our justice system, or how they're not achieved as well, with some weaknesses of the content. So the first principle of justice is fairness. So fairness involves treating people fairly, as you can imagine, but making sure everyone gets a fair opportunity to present their case, have their voice heard, and get chances to have a fair outcome as well. So sometimes that means that people need to be treated a little bit differently. So with equality means everyone's treated equally, they get the same opportunities, and they're not discriminated against. Whereas fairness, not everyone will always be treated the same way, but that's to make sure they have an equal outcome. So for example, if you have a person that maybe is deaf, or they don't speak English, they would require an interpreter to make sure they have a fair process in the legal system. So they might be treated differently by having an interpreter, because not everyone will have an interpreter, but it does mean they reach that same outcome at the end, which is really important. So I know it can be a bit tricky, the difference between fairness and equality, but that's the main thing, whether or not they have the same opportunities, but they reach a fair outcome as well. So that's fairness and equality. With access, access means 2 things. It means understanding your legal rights, so understanding if you're a victim, what rights you have, for example, in the criminal justice system. But it also means being able to make use of legal institutions. So for example, if you couldn't afford a lawyer and you aren't able to have legal representation, that means that you aren't accessing the justice system the way that you should be. That's really unfair. So access is about making use of those institutions, so like being able to afford a lawyer and understanding your rights as well. So these are great to make sure you understand them. You don't necessarily need like one definition, but to have a good understanding of it, because the difference between, maybe mid-scoring students and high-scoring students is their ability to not only explain, for example, the role of Victoria Legal Aid, but their ability to link it to the principles of justice, so how it helps an accused to achieve access, as an example. Okay, I'm going to go through some of the key concepts of criminal law. So one important thing is that you understand the difference between summary offences and indictable offences, and some different types as well. So summary offences are minor criminal offences. So this might be things like, for example, driving offences like reckless driving, maybe drink driving as well, that are still serious in the sense that they're crimes and they're against the law. but not as serious as some of the indictable offences. So minor criminal offences, which will be heard in the magistrate's court for the most part, and with summary offences, because they're heard in the magistrate's court, there'll be no trial by jury. That's only in the county and Supreme Court instead. For indictable offences, like I said, they're more serious criminal offences that will be heard by a judge and a jury, only if they plead not guilty. So if an accused pleads guilty to a crime, they'll go straight to sentencing and won't have a trial with a jury. So examples of indictable offences are homicide offences, so things like maybe murder and manslaughter, which would be heard in the Supreme Court, but other things like culpable driving, drug trafficking, assault, lots of other ones as well. And they're all found in the Crimes Act. So that's, you can always jump online and read through the Crimes Act if you want to see some more examples of indictable offences. Some other good things to know. So indictable offences heard summarily is sort of the in-between a summary and indictable offence, where all of the crimes are almost on a scale of seriousness. And indictable offences heard summarily is when there's an indictable offence and it's not sort of at the top level of seriousness of a crime. So something maybe like murder or terrorism, that would be a really, really serious indictable offence. But there are some indictable offences that aren't as serious and they're sort of almost sitting at a summary offence, but not quite. So what can happen with these offences is an accused that's been charged with a crime, with an indictable offence, can apply to the magistrate's court to have their case heard as a summary offence instead, which would be beneficial for an accused because it means you don't have a full trial with a judge and a jury, it's just with a magistrate. It will be probably a less serious sentence as well if they are found guilty. So it's very beneficial if you're an accused, you would want to have your offence heard as a summary offence. So it's important that you don't just know summary and indictable, but also indictable offences heard summarily. So the few other things you need to know for key concepts is the burden of proof. So this comes up in civil as well, but specifically for criminal, or what the burden of proof means is it's the party who has the responsibility to prove the facts of the case. So in a criminal case, this would be the prosecution, which just means that the prosecution, their job is to prove the guilt of the accused in this case. So that is their responsibility to provide evidence to build their case and prove the guilt of the accused. The standard of proof is what they have to prove. So the extent of the guilt that they have to prove. So in a criminal case, the standard of proof is beyond reasonable doubt, which means if you are found guilty of murder, for example, it can't sort of just be like the accused has some evidence and it's like a 55% chance that you're guilty. It needs to be like 99% sure there's pretty much no doubt at all that you are guilty. So it's a really high extent, which is really good because it achieves the presumption of innocence. So you'll only be found guilty of a crime if they're really certain that you are guilty, the jury has no doubts, or the magistrate or the judge has no doubts as well. So presumption of innocence means everyone has to be treated innocent until proven otherwise. So this can be upheld through the standard of proof because it's so high. Also through granting bail as well. So if you're charged with a crime and you're granted bail where you are free to like roam through society, what that means is you're being treated as an innocent person, because if you thought someone had assaulted a person, you assumed that they're guilty, you wouldn't let them free in society, right? So it shows that you're treating them as innocent until the prosecution can prove your guilt instead. So those are all of the key concepts. Now we're going to move on to some of the other content. So the next dot point is about the rights of an accused in a criminal trial. So the accused has three rights, well, at least three rights that you have to learn. So the first right is to be tried without unreasonable delay. So what this means is when the accused goes through the trial process in their criminal proceedings, they can't encounter any delays that would be considered unreasonable, and emphasis on the word unreasonable as well. So for example, a reasonable delay might be something like COVID. When COVID hit the courts, they said we will have to go home, and there was a big probably delay in figuring out how to transition cases online. An unreasonable delay would be the prosecution just forgot to bring their witness to court on the day. That's sort of not fair for you as an accused. So emphasis on the word unreasonable. It doesn't mean there's no delays at all, but the court has to try their best to try to minimize all delays. So this applies for all accused in all of the courts, and it comes from the Human Rights Charter as well. Right to a fair hearing has two parts. So this, as you can imagine, would try to uphold the principle of fairness. And what it means is that an accused in their case has to have a judge or a magistrate that is independent and impartial. So they can't have any bias against the accused based on like prior convictions or anything they've heard in the media. So that's important to have an impartial adjudicator, whether it's a judge or magistrate. And the hearing must be fair and in public as well. So nearly all criminal cases will be open to the public, that anyone can just go in and watch. The only exceptions are more sensitive cases. So something like domestic violence cases or sexual offences where they need to protect the rights of the victim. They'll be closed off for the public in order to sort of protect them and they're not, too traumatized being in the courtroom. The third right is right to a trial by jury. So as you might remember from Unit 4, and which we'll talk about later today, this is an express right as well, but I'll talk about what that means later on. But right to a trial by jury means that the accused who's committed an indictable offence, so not a summary offence, they have the right to have a jury decide the final verdict, whether they're guilty or not guilty, which helps to have community input in the decision, and it's not just a judge making all the decisions instead. So those are three rights of an accused. Next, we're going to talk about rights of victims. So the rights of the victims, the first one, sort of the biggest one, the right to give evidence as a vulnerable witness. So what this means is, like I was talking about before, sometimes there's really sensitive cases where victims have to have their rights protected. So the way they can do that is by giving them some alternative arrangements. So this would be victims of sexual offences, maybe other types of assault cases, but any cases where the victim and the witness needs to be protected in some way. So some of these alternative arrangements can include giving evidence not in the courtroom because they might not want to face their accused or other people if they feel traumatized or if they feel embarrassed. So they can do it in a separate room. They can do it through video, like through Zoom or something as well. They also can ensure that the accused doesn't ask the victim any direct questions because that could be quite traumatizing. They might have a support person as well. So it might be like a family member or a friend there to support you as you give evidence. So this is to ensure, first of all, that the victim and the witness doesn't endure extra trauma, because that would be really unfair for a victim to have to sort of relive the experience of the crime. But also it means the prosecution can ensure that all evidence is reliable, because if you've got a victim that's really sort of in distress giving evidence, that's no good for the prosecution because they can't really rely on that evidence because they don't know if it's the truth or if it's sort of been muddled by that stress as well. So two other rights of the victims: right to be informed about proceedings. So this right is that the victim of a crime has the right to be informed about everything that goes on in the trial. So not just in the trial, but before and after as well. So for example, if that they would be informed about what an accused has been charged with, like what crime. If there's no charge, why they haven't been charged with this crime. The date of the trial, the outcome of the trial, if there's going to be an appeal, what the sentence was, are they going to jail, how long for, all of those sort of things to make sure they're informed about their proceedings. Then this third right, final right of the victim, is very similar. So it's the right to be informed of the likely release date of the accused. So what this means is it's sort of the same thing that they're informed about proceedings, but it's a bit more specific. That if your accused was found guilty and they were sent to jail, the victim has the right. There we go. Sorry, I just fixed the audio problem. The victim has the right to know if their accused is in jail when they're going to get out of jail, because you can imagine that would be quite traumatizing. If your accused is in jail, you'd feel quite safe and you feel protected, that you're not at risk of, being assaulted again or something like that. But you would have the right to know when they come out of jail as well. So the state has to give a victim at least 2 weeks notice, 14 days, of when an accused is going to be released from jail to make sure they feel protected. Okay, next is role of institutions, so VLA and CLC. So VLA, Victoria Legal Aid, is a government agency which gives free legal advice to the community, so to accused, to maybe witnesses and victims as well, and often can give either free or very cheap legal representation to people. So this sounds great, right? Would help improve access for those people that can't afford a lawyer, will help them to make sure they feel like they can access the justice system in a really efficient way. But a big weakness of VLA is they have very limited funding. So what that means is, because they get funding from the government, but because there's not quite enough for everyone, means some people are going to be stuck that they can't afford a lawyer, but they're also not eligible for legal aid. So they get sort of stuck in the middle, which is not ideal. As you can imagine, that then they're stuck and they have to represent themselves, which would be a very hard thing to imagine if you had to go to court and represent yourself without the help of a lawyer. It would be a really tricky thing to do. So that definitely reduces the ability of VLA to achieve access. So when they do help people, they're fantastic in sort of closing that barrier, but that's definitely a big weakness, that they can't help everyone, which is a shame. So community legal centres, CLCs, you also need to know their role, which is quite similar. One difference between them, so they still offer free legal advice, sometimes representation, just not as often maybe as VLA, is that CLCs have two different types. So there's generalist CLCs, which are just based on location. So it might be like Fitzroy Legal Service, Williamstown Legal Service, Melbourne Community Legal Centre, something like that, where it's just based on location and will give all different types of advice. Whereas specialist CLCs are focused on particular types of law. So youth law, for example, there's a refugee legal centre to help improve access for refugees in the legal system. Things like that. They're more specific types of laws to target the people that they can help. Okay, next bit of content is committal proceedings. So committal proceedings, what you really need to know is about committal hearings, what they are, how they function as well. So committal hearings is where, for an indictable offence, the accused will go to the magistrate's court. So remember, indictable offences are heard in the county court and the Supreme Court, but the committal proceeding that happens before the trial will happen in the magistrate's court. So that's important to remember. So the magistrate in these proceedings will decide if there's enough evidence to go to trial. So what will happen is the prosecution will present their case and they'll say, this is all the evidence that we have so far, and then the magistrate will decide, is that enough evidence to go to trial? If the magistrate thinks that's not a very strong case, because of the presumption of innocence, where we have to treat the accused as innocent until they can prove otherwise, they might acquit the case and dismiss it and say, no, it's not enough evidence, we're going to let them go for now. So that is a good way to achieve fairness, to make sure that the accused is treated as innocent. The other thing that will happen, if there is enough evidence to go to trial, the accused will plead guilty or not guilty. So if they plead not guilty, it will go ahead to trial. If they plead guilty, they'll skip the trial process and go straight to sentencing by the judge to decide what their sentence will be, whether it's a fine, community corrections order, imprisonment, or something like that as well. Okay, I've sort of gone through strengths and weaknesses. So another good thing is that it saves time and resources if it ends up that the accused pleads guilty. So if you were in a committal proceeding, you might see the prosecution has a lot of evidence. So let's say it's like a murder case and the prosecution have you on camera killing this person, right? That doesn't look too good for you. And you might decide, okay, I don't really stand much of a chance in my trial, so I'm going to plead guilty and go straight to sentencing, because if you plead guilty early on, it makes you look much better. It acts as a mitigating factor that we'll talk about in a minute as well. So you might get a more lenient sentence. So it can be really helpful for that. Even if you don't plead guilty, it helps you be aware of the evidence that the prosecution has, so you can prepare your defense in your trial as well. Okay, plea negotiation. So this also happens before the trial of before a criminal trial. So plea negotiations are discussions that happen before the trial between the accused and the prosecution. So it's sort of outside of the courtroom. This can happen for summary and indictable offences as well. So it'll be a discussion where the prosecution says to you, okay, if you plead guilty, I will drop one of your charges. So if you've got 3 counts of assault, they'll drop it down to 2. Or let's say if you're charged with murder, they'll say, okay, if you plead guilty, we'll change it to manslaughter instead, which is a less serious crime. So that can be really good in order for you to, again, be more informed before making your plea. And the prosecution would want you to plead guilty so that they can skip a trial as well, because that's a lot of time and money involved in a trial. And it can help you to be more informed about your rights, which would help you to uphold access as well. So sentence indications are another pretrial procedures. This is the last one before we keep going. So this happens within a court. So it's a discussion with a judge where if you're accused of a crime, so let's say murder as the same example, you ask the judge, if I were to plead guilty now, what would you give me as your sentence? So this can happen for indictable and summary offences. And what will happen is the judge will say, okay, if you were to plead guilty, I'd give you 8 years in prison or something like that, right? And it helps you be more informed before you make your plea. So if the judge says to me, okay, 8 years of jail, I might think that's no good. I don't want that. I'm going to really fight in trial and try to be found not guilty. So it can help you be more informed. If that happens, the judge can't think that was really suspicious that you asked, what if I pleaded guilty, right? It might make you seem suspicious, but they can't use it as evidence against you. So it wouldn't sort of hinder your case at all. It can't be used as evidence at all. So the purpose is, again, to make the accused more informed before they make the decision, and to try to lead to a guilty plea as well, because whenever the courts can save the time of a trial, they'll want to do that as often as possible. Okay, next is reasons for Victorian court hierarchy. So the court hierarchy is really important in almost every area study that you do. That it's good if you can to learn this court hierarchy. It's not too tricky. So magistrates at the bottom, then the county court, Supreme Court, which has, remember, trial division and the Court of Appeal. So they're two different courts within the Supreme Court, but that's the order. So it goes trial division, then Court of Appeal, and then the High Court at the top. The High Court's at the top of every court hierarchy in Australia. So it's good to know this, just it helps with case scenarios sometimes if you know which courts are higher than others. But what you really need to know for this dot point is the reasons why we have a court hierarchy. So the first reason is appeals. So if you, for example, have your case heard in the county court and you are found guilty, but you think that's a really unfair outcome, what you can do is you can appeal your case to the Court of Appeal. So you could move upwards and the Court of Appeal might review the case, make another decision. Whereas if all of these courts were on the same level, like it was like a flat stream rather than a hierarchy, you wouldn't have anywhere to appeal upwards to. So that would be really unfair, that you can't appeal your decision if you feel like it was unfair. So that's the first reason for appeal. So you can move upwards to appeal your case. The other reason for criminal law is specialization. So for example, the Magistrates Court has a really special expertise in summary offences and other things like bail applications, committal proceedings as well, whereas like the Supreme Court specialises in homicide cases. They're the only court that hears that. So that's another reason, is that having this hierarchy allows for specialties by the courts. So it's really important that you know for criminal these two reasons, and then we'll come back to it in civil with different two reasons as well. Okay, next is the roles of the parties. So you need to know the role of the judge, the jury, the parties, and the lawyers, the legal practitioners as well. So I'm going to quickly go through all four of them, and then we'll revise them as well when we get to civil law. So the role of the judge is to, first of all, like make the decisions, right? So the judge won't decide on the verdict. That's the role of the jury. If there is a trial, the jury will decide if they're guilty or not guilty, but the judge decides the sentence, which is really important. So whether you'll go to jail or you'll get a fine, that's up to the judge, and then how long for as well, or the severity of the sentence. And they always make these decisions very impartially. So no bias. They don't look at the prior convictions of the offender or anything like that. And also their job is to manage the trial. So make sure everyone's submitting their evidence, make sure the witnesses are doing the right thing, all of those things, just to keep things on track, act as a check on it, make sure there aren't too many delays or anything like that. So the judge has a really important role, and some other ones here that you can always read through later in the presentation, but emphasis on giving a sentence and managing the trial. They're definitely the most two important roles. Next, the role of the jury. So the jury, like I said, they will give a verdict of guilty or not guilty in a trial. There will always be a jury for indictable offences, not summary offences in the Magistrates Court, but always in the county and Supreme Courts. So this will just be everyday people like us who are just called in by the government from the electoral roll. They'll be picked randomly. You have to serve on the jury. So in a criminal trial, there'll be 12 jurors who will make their decision of guilty or not guilty. So like the judge, they have to be objective and unbiased and impartial, make sure there's no biases against the offender. So for example, if you were called onto the jury and like your best friend was the accused, you wouldn't be allowed to be on the jury because you have that bias of like the personal relationship. So you don't want to know the offender. You treat them as any other accused and you're really objective. You don't do any research in the media as well. That's really important. So in some cases, like, for example, if, I don't know, let's say it was like Taylor Swift that's been charged with murder or something and you're in the jury, right? If that was the case and you know lots about this person, maybe you're a really big fan of her, and you're reading lots in the media about, oh, what, is she guilty or not? That's not appropriate. You're not allowed to do your own research and you're not allowed to bring any of those biases in with you. So you've got to be totally unbiased about all of that when you make a decision on the jury. Okay, the role of the parties is to give an opening address. So say, this is my case, this is how I'm going to defend myself. The prosecution will do the same. So both parties, the accused and the prosecution, then they'll give their evidence and present their case to the jury and or the judge. Give a closing address, just follow all orders given by the judge as well, and always be there in the trial. So that's the role of the parties, to present their case. The role of legal practitioners, so lawyers, is to present their case for the accused in the best possible light. So they want to help them as much as possible, but only to an extent, because they also have a duty to the court. So they have to make sure that they can't mislead the court, they can't lie to the court. So lawyers often maybe don't even want to know if their client is guilty, because if they know that they're guilty, they can't go into the court and lie about it, right? So they present all the evidence that they know, but they'll try to help their client in the best way possible, and always inform them of their rights, help them present their evidence, and help them understand the court proceedings as well. Okay, we're getting to the end of criminal law, which is exciting, but the next thing to look at are the purposes of sanctions and the types of sanctions as well. So there's 5 purposes. I've put them in this order because I think it's helpful to learn PPDDR. Doesn't really stand for anything, but I think it's a bit easier if you can learn the letters in that way. It helps it to be able to recall that information. So punishment, protection, denunciation, deterrence, and rehabilitation. So punishment is pretty obvious: to punish the offender, make sure they're penalized for the crime that they've committed, whether that's through money, through sending them to jail, through making them do community work, but making sure they're punished for the wrongdoing that they've committed. Protection is to protect the community and make them feel safe from this offender. So for example, if you've got a serious murderer, sending them to jail will protect the community because it removes them from society. Whereas maybe something like a fine, for example, will not achieve protection because they pay a bit of money, but then that's it. They're still free to roam through society. You know, they're not taken off the streets. For example, if you get a fine for speeding, you're still driving on the roads. Unless you lose your license, you're still driving on the roads and you're a risk to society. So fines maybe don't achieve protection as much. Denunciation is where the judge will say, I'm giving you this sanction, like imprisonment or any other one, because you've done the wrong thing and society doesn't approve of it. I don't approve of it, so you need to be punished for that. Deterrence is to try to prevent reoffending. So whether that's of the specific offender, we don't want them to speed again, or to prevent society in general from committing this crime. So if someone gets a fine for speeding, you know that when you're driving, if you have your license or your parents or anyone else, that I shouldn't speed, not maybe because it's the wrong thing to do, but because I'll get a fine if I get caught. So it sort of prevents people from committing crimes. 5th reason, which is also important, is rehabilitation. So to try to help rehabilitate the offender of any underlying conditions, whether they have maybe addiction issues, maybe to try to educate them. So for example, when they come out of prison, hopefully they're a bit more educated and rehabilitated, so they're less likely to commit crimes again in the future, and then they're a bit more beneficial to society as well. So I've already talked about these sanctions, but the 3 you need to know: the first one is fines, so where you pay money to the state. So think about, with all of these sanctions, do they achieve their purpose or not? So for example, fines don't achieve protection because they're not removed from society. Community corrections order. So this is where the offender will have to provide community work. For example, like cleaning up a beach, or I don't know, something like that, or there'll be other programs as well to sort of keep them busy and sort of as a form of punishment for the crime that they've committed. So some conditions include things like Obviously, you're not allowed to commit a crime while you're never allowed to commit a crime, but especially not on a community corrections order. Following directions given by your officer. Tell anyone if you have changed your address or any contact information so they can find you. And you can't leave Victoria without permission, or the country as well. So again, they can always find you and you sort of can't run away from the police. Last one is imprisonment. So imprisonment is where you'll remove the offender from society in order to try to protect the community. And this is the most serious one and will often only be used as a last resort. So judges will try to implement fines and community corrections orders when they can, but if there's nothing left, they will have to implement imprisonment, which is quite serious. Okay, so some factors in sentencing. So once the offender's already been found guilty, they go to sentencing to the judge, and the judge will think about these things as a way to influence their decision about what sentence they'll get and how serious it is. So aggravating factors are things that make the offender look worse. So for example, if they robbed a shop, they committed theft, that might not be super serious, but if they were really violent, maybe they assaulted an old lady on the way out or something, that will definitely make the crime more serious. If they did it with a weapon, they threatened to pull out a knife or something like that, that will make them look worse. And just the type of offense as well. And so it'll depend on the circumstances. So you might get a question in the exam about aggravating factors and giving examples. I think I had one in my exam like that. So you just need to be able to look at the facts of the case and decide, well, what makes it look a bit worse for the offender? So that would increase the seriousness of the sentence. Then there's mitigating factors as well. So these are things that do the opposite and make you look better instead. So something like maybe you're charged with assault, like you're out at the pub and you are charged with assault because you punched someone on the street, which is terrible. But what would make you look better maybe is if you're provoked by the victim. So maybe they said something really discriminatory against you, or maybe they pushed you first or something. So you're still charged with a crime, but it lessens the seriousness of your offense. And also if you show remorse and you feel really sorry for what you've done, if you plead guilty maybe early on, that will make you look better as well. So that's another factor in sentencing, whether or not you've plead guilty, because if you plead guilty and you're saying, I'm really sorry for my crime, I know I've done the wrong thing and I need to be punished for it, makes you look a lot better. Whereas if you don't plead guilty and you're saying the whole time, I'm innocent, then they find out you're not innocent, maybe it makes you look a little bit worse. Victim impact statement is the fourth factor in sentencing. So think about, the seriousness of how the victim has been impacted by this crime. And, if it's, a crime that's really ruined the life of a victim, the accused really needs to be punished for that. So a victim will give an impact statement and read out, how these crimes impact their life, and the judge will take that into consideration. So, if the victim says, I want this person to go to jail for the rest of their life, it doesn't mean the court will do that, but it means they'll at least think about the severity of how the victim has been impacted by this crime. Okay, well, it's almost at the end of criminal law. You guys are doing a great job, and we'll get to a break soon, I promise. But the last thing you need to know are reforms and factors related to how justice is achieved. So with criminal reforms, you need to know time factors, cost factors, and cultural factors. So cost factors are things like whether or not an accused can afford a lawyer. If they can't, can legal aid like VLA, can that assist them? If not, and they're self-represented, how much assistance are they getting by the courtroom? So things that make the principles of justice more likely or less likely to be achieved. And then you also need to know one recent and one recommended reform. I haven't put in specific examples because I know every school learns different ones, but I just wanted to flag that it is really important that you do learn them because they definitely can come up in the exam. So make sure you have one recent reform, so a reform that's actually happened, and one that's been recommended. So recommended might be something like more funding for legal aid. So it hasn't happened, but could be recommended. And make sure it's from the past 4 years as well. That's really important. So between 2017 to now, anything in between them. Time factors, you need to learn things about delays and how that can reduce fairness for an accused because maybe it's stressful. But how maybe things like plea negotiations and sentence indications can help with these factors because they can speed up the process if it means you get to skip the trial. And then again, learn your recent recommended reform. A good way to learn these is also just to keep up with the news if you're not already, because a lot of these are still happening every day, new reforms that are being implemented. So it's good to keep up with the news to maybe give you some ideas for reforms to learn. Last factor, cultural factors. So these are things to do with maybe language barriers, cultural barriers as well. Things like how Indigenous people are overrepresented in our prisons, not because they are innately, more criminal people, but because the system there's a lot of barriers for them in the system in terms of language or cultural taboos, or they're not provided as much support as other people. So those are some good things to learn as well. Then your reforms, and then that is it, I'm pretty sure. Yeah, for criminal law. So we're going to keep going with civil law and then have our question time and break. So if you thought of questions, make sure you are on Mentimeter, which is the code's still down there if you're not already on there. But otherwise, we're going to keep going with civil law. So key concepts for civil law: instead of the accused and the prosecution, we now have the plaintiff and the defendant. So the plaintiff is the party who initiates a civil case. So unlike criminal, where you're charged with a crime, the plaintiff says, oh, something bad's happened to me, whether someone said something bad about you, maybe you've had like a workplace incident, and you initiate the case, and it's like suing a person. That's what you would maybe hear on TV or something, but they initiate the civil case against the defendant. So the defendant is the person that's sort of done something wrong, and they're having to defend themselves in the courtroom. The burden of proof in a civil case is on the plaintiff. So they're the one that's initiated the case. So they have the job to prove that the defendant has done something wrong, that they're liable. They'll have to prove the standard of proof, which in a civil case is the balance of probability. So in this case, it is sort of a matter of like 50-50 who's more likely to be in the wrong, unlike a criminal case where it's such a high standard of proof. So balance probabilities means, who is more likely to be in the wrong? Even if it's like 51% chance it's this person, it's not as strong as beyond reasonable doubt. Another key concept are class actions or representative proceedings. Same thing, just different ways of talking about them. So I'll call them class actions for now. So class action is where a group of 7 or more people, has to be at least 7 for it to be a class action. They group together, that they've had something similar happen to them. They group together as one big group plaintiff against the defendant. So it might be like, for example, there was one night at a restaurant where like 50 people got food poisoning, and 10 people sort of gang up together to have their case against the defendant to like sue the restaurant or something like that. So really important though is 7 people. That's important to know. So this can be great because it's less stressful if you've got other people there, and it's like not all the responsibility and eyes are on you. Also, you can share the costs with other people. So it's like a much cheaper alternative, which would help to achieve access. So you either share the cost, but you can also get a litigation funder as well. So sort of like a third party that will help fund the class action for these people, and they'll get a bit of the settlement back. So they get a bit more money if they're successful at the end. Okay, there are some factors that are really important for you to learn while you're, as a party initiates a civil claim. So you need to think about negotiations. So negotiations is just having a chat with a person. So for example, if I'm having a dispute with my neighbor, let's say they've built a fence and I don't like the fence that they've built, before taking them to court, I should just have a talk to them, right? So talking to them to say, hey, I really don't like this. Can we figure out a compromise about this situation? If that doesn't work, then you can initiate your civil claim, but it's worth at least trying to negotiate with the person that you're dealing with. Costs as well, you need to think about, can you actually afford to go to the court? So a lawyer is very expensive, probably tens and thousands of dollars you're going to have to invest. Me as like a uni student, I would think, well, maybe not, it's probably not worth it if I have to pay for a really expensive lawyer for a few weeks or months even, because you might not even be successful at the end. You might not get damages. So that's something important to think about. Limitation of actions means that you need to think some cases have sort of like expiry dates. So I think, for example, defamation is a year, maybe 2 years. So after that, like 2 years expires, what happens is sort of runs out. They'll say, sorry, too late. You should have done this last year and you can't bring your case anymore. So you need to think, has that time limit run out or not? Some cases won't have that time limit. For example, like sexual offense cases, they don't have any limits because it can take a lot of time for those people to process what's actually happened to them. Next is scope of liability. So this is where you need to think who is actually in the wrong. So for example, if you got food poisoning at McDonald's from like a hamburger that you've eaten and you want to have an action against them, are you going to sue the 15-year-old that's made your burger, right, working his shift on the weekend, or are you going to sue his boss or like the CEO of McDonald's? So you need to think about who's actually in the wrong and who is responsible. And then last one, I think, is enforcement issues. So, okay, if you actually are going to sue a person, are they going to be able to pay for it? Maybe they're bankrupt, for example. If you're going to sue them for $1 million and they don't have $1 million, how's that going to work? Maybe they're overseas. Maybe they're in jail. So different things to think about of how you can actually receive your damages if you're successful. Okay, on to CAV. So CAV is Consumer Affairs Victoria, which is a body that tries to resolve disputes related to consumer affairs, as you can imagine. So what they'll do is they'll use conciliation as their dispute resolution method, which I'll talk about more in a minute. But it's really sort of cheap. They can do it over the phone as well, which is really useful. But it's a way for people to have their case heard and resolved without having to go to the courts, which can save a lot of time and save a lot of money as well. So if you get a case, I think we'll look at a question later, but is CAV appropriate? Think about how much it costs. It's cheap, so it's probably going to be a good option, but is it consumer affair? So if it's something about my neighbor and their fence, that's not a consumer affair, so I wouldn't be eligible to go to CAV. And maybe there's a better option instead. VCAT is similar to CAV, that it provides like an alternative way to hear disputes outside of the courtroom, but they have a bit of a wider scope of their jurisdiction, so they hear a lot of different types of cases. Their main dispute resolution method is like mediation, which again is like conciliation, is pretty informal. It's not like a full courtroom, and they'll try to provide it's not free but cheap dispute resolution methods where you only pay like a few $100s rather than 20,000 or something like that. So you got to think, is it in your jurisdiction? So it's got a more wide jurisdiction than CAV, or are there other or better ways to resolve the dispute as well? So I've sort of already gone through these strengths and weaknesses, so I'm going to keep going. Okay, so next, pretrial procedures. So there's a few different types. So this one is pleadings. So pleadings is where I'm the plaintiff and I send you, the defendant, a statement of claim that says, I'm taking a civil action against you. This is why, you gave me food poisoning at McDonald's or whatever. And it will say, this is my case. This is why I'm filing my claim. And you'll send back to me a statement of defense that says, okay, I accept this. I'm going to take it to court because I think I'm in the right. And that will send out your different defenses and what you'll say in the courtroom. So the purpose is to outline the main claim so you know what each party is thinking and what evidence they have, and uphold fairness so you understand your rights. But also, if you're the defendant, you might think, no, I don't want to go to court. Let's settle this together. And they might have a mediation that's much cheaper than going to the courts. Another one, discovery of documents, that also will try to reach an out-of-court settlement where the parties will basically just see each other's evidence, and they'll see, okay, you've got all these medical records or you've got video footage, and it will help you to see how strong the other case is. So you might, again, not want to go ahead with a trial, but instead you settle it outside of court. Exchange of evidence is the same thing. We see each other's evidence, but instead it focuses on witnesses. So you'll have expert witnesses, things like doctors, maybe teachers, scientists, something like that, where they'll have expert opinions about the matter, and then lay evidence and witnesses, just everyday people that have seen stuff. So again, if you see that someone has a doctor or a scientist on their witness list, you'll want to have the same thing as well. So again, same purpose, to help achieve an out-of-court settlement. It might want you to resolve the case out of the court, but then also can help you prepare for trial by knowing what evidence they're going to prepare. Okay, court hierarchy. I'm not going to talk about it too much because we already did before. Appeals is the same reason. So also in a civil case, we have the court hierarchy, so you can appeal upwards. Another reason, though, which is a bit different. So for civil, you don't say specialization, you say administrative convenience instead. So cases are distributed based on how serious and complex they are. So for example, if you're suing a company for $5 million, you're not going to go to the magistrate's court because they're lower down in the court hierarchy. They have cases between 10 to 100,000, but you'll go to probably the Supreme Court instead because it's higher up in the court hierarchy. So that's just distributing the cases based on where they sit in the court hierarchy. That's all that means, but important that you have that reason instead of specialization. Okay, key personnel. I'm not going to talk about the judge again because that's all the same, and I want to make sure we get through all our content, but I will mention for the jury that in a civil trial, juries are optional, so they won't always have them, and the plaintiff will have to pay for a jury if they would like one. And also, instead of 12 jurors, there'll only be 6 in a civil trial. So that's an important thing to know. Otherwise, if there is a jury, they'll have the same role as in a criminal trial. Same thing for parties and legal practitioners. The only difference is that they have to both comply with overarching obligations that are in the Civil Procedures Act. So it might be worth looking up the legislation. That can be a good way for you to understand it. But all it really means is things like you can't mislead the courts, or you have to do your best to present your case. That's stuff that I've already talked about before, but they're specifically in legislation for civil trials. So that's important to know about as well. Okay. This is case management powers. So these are powers that the judge has to manage the trial. So the first one is the power to order mediation. So all this means is that the judge, if they think this case shouldn't be in the court, this should be settled outside of the court, they can order the plaintiff and defendant to go have their case resolved through mediation. So they have the power to do that before or during the trial at any time, really. If it doesn't work, they can come back, but it's a good way to try to free up the court's time and resources and help save money for the parties as well by resolving it through mediation. The other power they have is to give direction. So this includes mediation, but might be other instructions like you have to submit your witness by this time, or this is the timeline of the event, or I need you to show me your bank details or other evidence that they have, or I need you to fix this document. So really specific directions about how the court is working, just to make sure everything's running really smoothly in the case. That's the main purpose of that power. Okay, dispute resolution methods. So we've already talked about a few of these, so I won't go too in depth. But dispute resolution methods, you've got mediation, which is where you'll have 2 parties with an independent third party who just sort of facilitates discussion, but they don't offer any suggestions. So it's really a lot of party control, and the plaintiff, me and you, the defendant, for example, we reach our own outcome, and it's really balanced discussion, which is good. Conciliation is the same thing, except the conciliator, the third party, they can offer suggestions. So, okay, you're both fighting about the fence. How about you pull down the fence and you both agree on a new one that you get together? They don't have to accept that, and like they don't make a final binding decision, but they just can help to give those suggestions in case like the parties aren't agreeing on what they want to do. So that can be helpful. Arbitration is a bit different. It's a bit more formal, can cost more money because sometimes you might have a lawyer involved. But the arbitrator, again, is a third neutral party that will like facilitate discussion, but the parties don't reach their own decision. They help them discuss, but then the arbitrator, the third party, they make a final decision that's legally enforceable, which is called the arbitral award. So it's a bit more serious and binding than the other 2 methods, but some parties will want that. They'll want that binding decision because the other 2 aren't binding. Okay, getting towards the end, you guys are doing a good job keeping up, and then we'll have a break soon. But for now, I'm talk about remedies. So remedies are the order given by the court to sort of help the plaintiff get back to their original position and sort of compensate them for anything that's happened. So this will only be if the defendant is found to be in the wrong, they've been found liable. So the first thing is damages. So damages are money that's given to the plaintiff. So it might be $100 that compensate for like a watch that's been broken, might be $1 million. It really depends on the case and the seriousness of the case as well. So different types of damages. So we've got specific damages that have specific money value. So for example, specific damages might be to cover money you've lost when you've been out of work, or it might be covered to cover your medical bills or something like that, that has a specific amount of money that can be covered. General damages is a bit more vague. It's just for general suffering. So for example, if you lost a friend in a car accident, there's not sort of a price you can put on that. Yes, for medical bills and things like that, but you know, losing a loved one, there's no price that you can pay for that. So it's a really general estimate about how much money you deserve to be compensated with. Injunctions is the other type. So injunctions is to either stop someone doing something, which is a restrictive injunction, sorry, tongue twister, or it can be a mandatory injunction, which forces you to do something. So a restrictive injunction would be like, I'm forcing you to, or let's say mandatory injunction might be like, I want you to pull down the fence. It forces you to do something. Restrictive says you're not allowed to do it. So you're not allowed to pull down the fence. Okay, so that's the difference between those 2. Okay, there's also reforms. The only difference is instead of cultural, it's accessibility for For civil law, which means it's not just about cultural things, but also about maybe where you live. So if you're in a rural area, how you can access the legal system. Same thing, you need to learn all your reforms for all of them. So make sure you do, because that's really important. But again, keep up with the news and you should be fine to keep up with that. So that's good work following along for people listening. But those are all of the civil and criminal laws. That's all of Unit 3. What we're going to do now is we're going to switch over to Mentimeter. So I'm just going to stop sharing the PowerPoint for a minute. And awesome, I can see we've already got some questions, so we're going to get to that in a minute as well. I'm just going to, sorry everyone, share my screen again. And we're going to go through a little bit of a quiz, which is really exciting. So I will come back to these questions in a minute, I do promise. Okay, so do fines achieve their purpose of protecting the community? So I'd love if you guys, awesome, we've got people answering it. So either yes, they achieve protection and they protect the community, or no, they do not. So awesome, we've got a lot of people, keep sending your answers through, but majority of people saying no, they do not achieve protection, which you can always argue for either way. There's technically no right answer, but I would agree with the majority of you and say, yeah, they don't achieve protection, just because, like I said before, the offender is still free to roam in society, which doesn't sort of protect people. So you've still got that dangerous driver out on the street. So awesome work. I'm going to skip over to the next question. Good work, everyone. You've sort of got that one down. Oh, except I think I've missed some questions. Let me go back. Sorry guys, give me 1 second just to check. Mentimeter. All right, 1 second. I've nearly got it ready. You guys are doing a great job with content and getting these Mentimeter questions as well. Okay, so this is the next question. So a mandatory injunction is when the defendant is restricted from doing something, so they're not allowed to build a fence, would be an example. So is this true or false? I'll give you a second. Got some answers coming through, which is awesome. Okay, we've got one true, but a lot of false, which I would agree with you guys and say that that is a false statement. Instead, this is not a mandatory injunction, but this would be a restrictive injunction. So you're not allowed to do something. The mandatory injunction would be you have to pull down the fence or you have to build the fence instead. Awesome work, you guys. That is great work. I think there's one more question. Yeah, okay, so one more question before our break. So which of the following is not a type of condition for a community corrections order? So no reoffending, notify change of address, or not initiating a civil claim. So which emphasis on not, which is not a type of condition? I'll give you a second to answer that. Awesome, looks like we've got a pretty big majority for not initiating a civil claim, which is true. So you can still initiate a civil claim, but you do have to notify change of address if you're changing your address so they can find you, and you're not allowed to commit any crimes or reoffend while you're on your community corrections order. So great work, everyone, on that. I'm just going to get out of Mentimeter, back into our presentation. So now we've got a bit of time for questions. So I'm going to go back onto our question slides. Sorry, give me 1 second. Okay, awesome. We've got a lot of questions and we won't have time for all of them, but we've got more time to come back to questions. So I'll leave a few minutes now for some questions. So this is awesome. And you guys can, like you can see here, you can upvote any questions that you also want me to answer. So now, and Raquel, also feel free to jump in if you've got any advice as well. But what is the most effective method for studying for the exam? So what methods should we take to revise? My personal advice, and it really depends on what type of learner you are, but making sure, first of all, you've got a really good sort of umbrella understanding of the content. So hopefully today will help with that, to make sure you've gone back over it all. It's there sort of fresh in your brain and there's no gaps in your knowledge. If you feel like there's big gaps, maybe going back through your notes, maybe doing a bit of rote learning or explaining to a friend a bit of the content, but that shouldn't take up too much of your time. So once you sort of got down the general content, I think just application and practice questions is really the best way to go. At least for me, that's what I did in year 12. So as you know, it doesn't have to be full exams, but as many questions as you can. There's a lot of them just for free on VCA, exams from 2018 onwards and the sample exam. Even just doing one question at a time, really slowly with your notes, it's a really good way to apply your knowledge and practice those exam questions. So that would be my advice. Get a broad understanding of the content, and then exam questions will really help as well. I will give some more study tips, but Rikea, did you have anything to add about study advice?
I think the way I studied best was just getting someone to ask me questions. So I will write down the questions and I'll write down the answers, and then I'll put it all together and get my friend to ask me those questions so I could speak it. And it was so much easier for me to speak it and later on remember it and write it down in my exam. And also cue cards are also really good to remember. You could just write, like, for example, the burden of proof or standard of proof for criminal, and then on the back of it write the answer. Especially if you're a visual learner, you can do drawings or anything that could help you learn, but definitely do as much practice exams as possible and get your friends to ask you questions, because I found that is the easiest way to remember.
Yeah, awesome. I definitely agree with that. So I hope that helps, but we will come back to more exam stuff later on. So I'm going to mark that as answered. How much time should we be spending on the 10-mark question exam? That is a great question. So technically, because you've got 80 marks and it goes for 2 hours, the sort of ratio is 1.5 minutes per mark. So for example, technically on a 10-mark question, that should be 15 minutes that you spend on it. But I know that's a really tricky thing to do. So my advice would be to try to get the small questions, like 2 and 3 marks, done as quickly as you can. You know, not like 3 seconds, like make sure you spend time getting them right. But, you know, instead of 4.5 minutes on a 3-mark question, maybe 2 minutes that you get it done. So then once you get through those smaller questions, you should hopefully get a little bit more time on your 10-marker. So I would say in an ideal world, 15 minutes, because that's sort of the ratio. But, you know, I would say up to 20 minutes. But once you get to that 20-minute mark, I would just stop, keep going, and you can always come back to it if you've got time left at the end of the exam. My advice also would be to probably not start with a 10-marker. I know that seems like probably a good idea, but if you start with a 10-mark question, what that means is that you might accidentally spend 25 minutes on it because you really are trying to get it right, and then you run out of time because you have to have really good self-control to make sure you stop and you keep going with the other questions. Because yes, 10 marks is a lot, but it's only 10 marks out of 80. You know, there's a lot of other questions on there. So my answer for that, in an ideal world, 15 minutes, but 20 probably at the most. And to do when it feels right. So maybe somewhere in the middle, maybe you just want to go in order of the exam as well. But great question. I hope that helps. I'm going to mark that as answer. Do we get access to these slides after lecture? That's a great question. Yes, you should be able to access it through, maybe Rikea, do you want to explain through Venti how they can access the slides?
So all of you should have access to Eventi when you came into this lecture. So when you press on Legal Studies, on the right-hand side, you will see I've uploaded the lecture slides there. And at the end of the session, I'll also send you a link in the chat so everyone can access it. And also we had a lot of questions about recordings. You will have access to recordings within 48 hours of this session, and that will also be on Eventi.
Awesome. Thanks so much. All right, I'm going to mark that as answered. And I know we've got a lot of other questions in here, but just for the sake of time, we've got more times for questions later. I think another 2 blocks for it. So we definitely will answer as many questions as we can, but keep asking them, keep upvoting them as well. So we'll answer as many as we can. For now, we're going to have our 10-minute break. We're pretty good on top of timing. So just to start us off the break, we've got an awesome video, if it's here, from one of our amazing UBS supporters. So I'm going to play this, and then we're going to give you about a 10-minute break. So the slide says 11:10, but we'll give you until 11:15, and then we'll keep going. But thanks so much for listening, you guys. And again, you've got Mentimeter if you want to keep asking questions, but stand up, have a stretch, get a drink, dance to our music that we'll be playing, but anything you need to refresh yourself so you don't get too fatigued from Zoom. Awesome. Just going to play this, and then we'll be into our break for 10 minutes.
Hi everyone, my name is Jeff Brown. I'm a credit analyst in asset management covering Asia Pacific. The highlight of my career would potentially have been giving a presentation on UBS TV to Switzerland with a Star Wars figurine while discussing the role of technology in Australia. I think My pathway to UBS was quite interesting. I came not only from a finance and economics background, but I also had physics and earth science. If I was to give myself some advice back in year 12, it would be two things. Firstly, if you do have free time and you're getting a bit bored, try and think to yourself, perhaps even the next exercise could be one of the marks in my final exam. So every little cent counts. The second one would be love yourself, back yourself. It's probably in the back of your brain somewhere. You don't have to overstress it. You'll be okay.
I've always thought about someone talking to themselves as being like a sign that they're kind of crazy. But the truth is that we all talk to ourselves like constantly. Like we have an inner chatterbox, a little voice. It lives in this part of your brain that's constantly going. Like it's constantly giving us advice and editing what we are thinking and what we should do and what everyone else is doing. Like that's always happening in our heads. So I've got an awesome idea. Like if you can decide what that chatter is in your head, oh my God, I promise you life will look totally different. And it really is. It's a matter of owning the fact that we do this self-talk anyway. Go, yeah, lean into that, I do that. And to tailor it in a way that actually really supports you instead of holds you back. Because the thing is that we are hardwired to be in constant self-protection mode. So that little voice in our head is constantly trying to keep us from failing, constantly telling us, don't do that, you'll look stupid, don't try that, you've never done it before, you should have all your ducks in a row before you even attempt that, which pretty much, like, this is probably the single biggest reason why people don't achieve their goals. It's probably the biggest reason why people don't even set the goals that would have them feel the happiest, because the fear of failing is so huge, and that little voice in our head is going, you're not quite ready. So here's the thing to try and practice, because it is a matter of practice. You know, it's a matter of starting here and practicing it and building your muscle around this. Here's the thing to try. When you find yourself thinking to yourself, man, I'm not ready, I need to do this before I could ever possibly do that, I should be more prepared, blah, blah, blah. All the stuff we say to ourselves that keeps us from actually doing the first step of what we want to do. Instead of saying that, just try it, practice, go, look, I don't have everything sorted out. I feel excited in some ways to try it. I'm going to try it. I could fail. I could look silly doing it. But it's one step towards me following my dream. And that bigger picture makes anything worth it. It's hard, like it's totally hard. It'll trigger lots of stuff in you. But the thing is that it will be the thing that has you grow and progress. And without growth and progress, like we actually feel like it's probably, you know, it's one of those things that makes us feel the least alive when we're just stuck and we're not making any traction in the stuff that's important to us. I really hope this helps. I would love to hear any questions, thoughts, comments. See ya.
Okay, hopefully you're all back feeling refreshed, ready to go. You guys are doing so well following along, and we're glad you've all stuck around. I hope that video was helpful. I feel like that's really inspiring about, you know, worrying about like nerves and failure and inspiring yourself. So I hope that was helpful, but let's get back into it. So I've
always thought about.
I don't want to watch it again. Okay, we're going to get into Unit 4 now. So we're halfway done with the content. So good work. If you're still following along, remember to keep asking questions that come up, and we'll come back to them later on as well. But otherwise, let's get into it with the content. So Unit 4 opens with, it's a bit different. We're not looking at the courts and criminal and civil law anymore. We're looking at Parliament and lawmaking, which is really exciting, and the High Court and the Constitution. So first thing you need to know, the role of Parliament and the structure as well. The role is really important though. So we've got two different parliaments you need to worry about. Commonwealth Parliament, as in our federal one in Canberra that makes laws for the whole of Australia, and then Victorian Parliament as well, which focuses on Victorian legend, of course. So first of all, in the Commonwealth Parliament, we've got the House of Representatives. So this is the lower house, which does most of the lawmaking. So they're representative and they'll form government. So currently we've got a Liberal government in the House of Representatives because they're the party that holds the majority of seats out of 150. So they will make laws, they'll introduce bills, debate them, scrutinize them. The opposition will, probably criticize the government, but that's their job, to make sure laws are as effectively debated as they can be. And it's important that they represent the people as well, to make sure that they're not only making laws with their own values and interests, but ours as well, as we vote them in and they're representing us as well. So that's the House of Reps. The lower house, their main role is to make laws and represent the people. Then the upper house of Commonwealth, we've got the Senate. So the Senate has 76 members, and the way they work is they're a states house, is another name for the Senate, which just means that the Senate has equal representation for each state. So if you haven't already, I would recommend you learn all your Australian states, because you'd be surprised. A lot of people don't know them in year 12, and that's totally fine, but would recommend them if you don't know them already. So we've got 6 states, and each state in the Senate has 12 members. So that all states have equal representation. So even though, for example, New South Wales is much bigger and more populated than Tasmania, it's great that in the Senate they have the same amount of representation to make sure they all have equal voices. So their role is to also initiate bills, but most of the time that will happen from the lower house. So the lower house will introduce a bill, then it will go up to the Senate, and they'll act as a house of review and review the laws that have come through to them. Sometimes they'll send them back and say, we've made some amendments, you need to approve it again. And that process will repeat until the bill has been passed, and then will be sent off to the Crown to get the final royal assent before it becomes a bill. So that is the Senate. So then we've also got Victorian Parliament. So the lower house in Victorian Parliament is the Legislative Assembly, has the same role as the House of Representatives. So to make laws, form government, be representative. So same role, just in a Victorian context. Then the upper house in Victorian Parliament is called the Legislative Council. So this also is the same role as the Senate, the upper house in the federal level. Only difference is, of course, they don't act as a states house because they're not members from different states. They're all Victorian, so they don't need to worry about having equal state representation. But same thing, they'll act as a house of review and keep a check on all the bills that are being passed. And then, like I mentioned, the Crown has to give royal assent. So the Crown is the representative of the Queen. So we're still a Commonwealth nation, which means that the Queen of England is our head of state. But of course, Queen Lizzie over in England isn't giving approval to every single bill that's being made. So what happens instead is she's got a representative at the federal level, which is the Governor General, and then the state level, which is the Governor. So the Governor General and the Governor can grant royal assent, meaning they approve a law, becomes legislation. They can withhold royal assent if for some reason they don't think it's appropriate, but that sort of rarely happens. And then they can appoint executive council as well, which just means the executive council sort of administer the law, make sure everything's running properly. They can act as a check on Parliament as well. That'll be like the Prime Minister and all the senior ministers as well. So that is the role of the Crown. Okay, next is division of lawmaking powers. So division of lawmaking powers is that when the Constitution was made 121 years ago or something like that, the people that made the Constitution said, we need to figure out who has power to make laws about what. So the different types of powers are residual powers, which are just for the state. So only the states can make laws on these areas. For example, education. That's why every state in Australia has a different education system. You guys are all studying VCE, the Victorian system. So each state has the power only over that, whereas like Commonwealth Parliament doesn't have any ability to intervene in education laws. Then there's exclusive powers, which are only for the Commonwealth, and the states can't intervene. So the states can't, for example, set up their own currency because only the Commonwealth can do that. Then there's concurrent powers, which are shared between both Commonwealth and state parliaments. So something like marriage, both states and Commonwealth Parliament can make laws regarding marriage. So it's good to know those 3 different types of powers and an example of each if you can as well. Next is Section 109. So Section 109 of the Constitution is really important that you do learn it. It's in a study design. And what it says is that when there is a conflict between a state law and a Commonwealth law, which would only ever be a concurrent area of lawmaking, because something like marriage, if you have a state law and a Commonwealth law, both about marriage, there's the risk that they're going to conflict and they're going to say contradictory things, right? So, for example, I think it was in 2013, the ACT government, so a state level government, they made a law that legalized same-sex marriage in ACT, and they technically had the power to do that because it comes under their concurrent powers, right? But the problem is the Commonwealth Parliament had the Marriage Act, which says marriage is between a man and a woman. So what happens there is that you've got 2 technically fine laws that they're allowed to make, but they disagree with each other. So what Section 109 would say is that when that happens and you've got these conflicting laws, the Commonwealth law will prevail and the other law will become invalid. I think that's supposed to say invalid, not valid. So what will happen? The Commonwealth law will prevail, and then the state one, they'll get rid of the contradictory section. So what happened, that ACT law was exciting, same-sex marriage was legal for a little bit until they said, sorry, the High Court said that's invalid because it conflicts with Commonwealth, and they go back to no same-sex marriage. So Section 109 is really important because it sort of resolves these tensions and makes it really consistent in all the different laws, but also might restrict state parliaments that, they might not want to make laws about marriage because there's the risk that they're going to conflict with Commonwealth laws as well. So it is really important that you do understand Section 109. Then the next thing we're going to talk about is how the Constitution acts as a check on Parliament's lawmaking power. So the first thing is bicameral structure. So all this means is that Parliament is bicameral in the sense that it has 2 houses, right? It's got the lower house, like the House of Representatives or the Legislative Assembly, and then the upper house, which is the Senate or the Legislative Council. So the Commonwealth has to have a bicameral structure, which is really important. So the Constitution says in Section 1, there has to be 2 houses. For state governments, it's actually optional. So, for example, Queensland only has 1 house. They're unicameral. Victoria, we have 2, but it's only for the Commonwealth that it's like constitutionally required. But it's really important that the Constitution says this in order to act as a check on Parliament. So if you've got 2 houses, it makes sure that bills are scrutinised before they're passed. So imagine if we only had 1 house. We had House of Representatives, and the current Liberal government, they've got let's say they've got a majority. If they make a bill, debate it, and they all vote yes on the bill that they make, that just easily passes through. The opposition can't really do anything to stop that since they've got a majority of seats, right? Which is good in that it creates efficient lawmaking, but it means that they're not scrutinizing the bills properly. So bicameral structure is important to act as a check that the Senate can act as a house of review in these cases. Next way it can act as a check is the separation of powers. So this is a bit different to the division. The division is about who has what legislative power, and then the separation of powers is different, that it's not just legislative power, but there's other types of powers as well. So we've got legislative power, the power to make laws, which Parliament has. Then there's also judicial power. So what we're talking about with Unit 3, that the courts have the power to enforce the law, so to run criminal and civil trials. Then the third power is the executive power. So I mentioned before the Executive Council that the Crown appoints. So their role, which is all the senior ministers and the Prime Minister, is to administer the law, act as a check on lawmaking. So the great thing about separation of powers is that you've got these 3 separate powers and not one of them has too much power. So imagine if Parliament, for example, wrote the Crimes Act, and I know it's a Victorian law, but just as a hypothetical example, they make criminal laws and say, murder is a crime or whatever, and you'll go to jail for it. But then imagine if the Parliament also had their own court where they enforce the laws. It's sort of too much power that they would have. So they set up the courts instead as a way to enforce the law separately and independently from Parliament. And then the Executive Council is also supposed to be independent from Parliament. The tricky thing is, though, then they're technically not, because the Executive Council has if it's got the Prime Minister and ministers in there, those people are sitting in the executive power and the legislative power because they're also sitting in Parliament. So technically, these 3 powers aren't totally separate. There's a bit of an overlap between the executive and legislative power, which is not ideal, because then it's not actually effectively maybe acting as a check. It still does act as a check, that it's still fairly separate, but you've got to be wary of that overlap as well, you know, when you're putting weaknesses in an answer, talking about the separation of powers. Okay, cool. I think we're going to come back to this question. I think it's accidentally slipped upwards in the slides, but that's okay. We're going to come back to it. We're going to keep talking about express rights. So express rights in the Constitution, and what they say is that Parliament is not allowed to make laws about some things, and that we have the right to them, and they can't be changed unless we get rid of them through a referendum. So, for example, we all have the right to freedom of religion. So you have the right to follow whatever religion you would like. You have the right to not follow a religion as well. Other ones, like you have the right to have a trial by jury, like we talked about before with rights of the accused. Did mention that this was going to come up in here. So what this means is that we have these rights to, you know, have a jury, to follow whatever religion we would like to, but it means that Parliament can't make laws about these as well. So if Parliament made a law banning a certain religion, someone could challenge that in the High Court and say they've infringed upon our express rights in the Constitution. They've gone beyond their lawmaking power. So that's a way to restrict the lawmaking powers of Parliament. Next, only two more ways to act as a check. So this one is the role of the High Court. So the High Court was set up by Parliament through the Constitution, the High Court as well, under Section 71, and they have the power to interpret the Constitution, which is a really powerful thing that they've, with that example, they can say, Parliament, you've gone beyond your lawmaking power. You are not allowed to legislate on the freedom of religion, for example. So they can restrict Parliament's lawmaking ability, and Parliament can't change their decision. So they can't say, no, we don't like that, we're going to reverse your decision. They can't interfere with the High Court. So the High Court is really important in acting as that check. Okay, last way to act as a check is the double majority requirement. So the double majority requirement is how the referendum system works. So a referendum is when Parliament wants to change something about the Constitution. So they can't just, you know, have a vote and say, okay, we want to get rid of freedom of religion, let's get rid of it. They need the support of the people. So they'll have a referendum to say, we want to abolish freedom of religion, for example, that we want to take it out of the Constitution. To do that, they'll say that in a referendum, and they'll send it out to people and say, do you support getting rid of freedom of religion in our Constitution? And everyone that's eligible to vote will vote and say yes or no. Okay, and the double majority requirement says what you need for it to be able to pass. So for a referendum to pass, you need a majority of voters in the whole of Australia to vote yes. So all 6 states and 2 territories, you need at least like over 50% of people to vote yes. Okay, but not just that, it also depends on states. So you need also a majority of voters in a majority of states to vote yes. So what that means is you need at least 4 out of 6 states, so not 3 out of 6, you need 4 out of 6 states to have a majority yes vote. So if, for example, if Victoria had 55% of people vote yes, then that's a yes for Victoria. So you need 4 states to vote yes to the change as well. So for example, if you have 80% of people say yes in the whole of Australia, but only 3 states say yes, then the referendum fails. You haven't satisfied the double majority requirement. So it's a really strict process, but that's a good thing, because you don't want the referendum, you don't want it happening all the time and always changing the Constitution, because the Constitution is sort of so important. It's not like a normal law, that we want to make sure it's consistent and Parliament doesn't interfere with it too much. And it means that Parliament has to be representative. They can't just change whatever they want to change in the Constitution. They have to always check with us instead to make sure they're being representative. Okay, now up to sort of the second part of this area of study, which I would recommend you are a bit more aware of than normal, because last year they cut this all from the study design. So I have a feeling, you know, no guarantees, but I have a feeling that VCAR might be sort of sneaky and give you a lot of these questions because they didn't do it last year and they want to sort of ask these questions while they can, but who knows what's going to be in the exam. So no promises, but just my little suspicion. But so the first thing you need to know is the role of Section 7 and 24 of the Constitution and a case related to it. So Section 7 of the Constitution says that it talks about the Senate and how the Senate is set up, and then same for 24 about the House of Reps. And what they say is that the Senate and the House of Representatives have to be directly chosen by the people. So there's nowhere in the Constitution or a law that says Australians have the right to vote. It doesn't say it like that, the same way it does in maybe America. But by saying those members of parliament are directly chosen by the people, it assumes that we vote for them through an election, which means we have a system of representative government. So that's where the system of representative comes from, these sections in the Constitution. Then what you need to know then is that, so what are section 724, but then a case that relates to it. So I'm not going to go through each case because there's lots of different ones. And again, like the reforms, I know every school learns different ones. So, you know, I don't want to give you a new case that you have to learn instead of the one your teacher's given you, but I've given you all the names of recommended cases. So these are all the ones I've done before when I did legal. You might find them interesting. You can research about them all online as well. So there's lots and lots of information about them. So for example, the Roach case, which is this one, is about a prisoner who challenged that a prisoner wasn't allowed, that they weren't allowed to vote in elections. And Roach said that, the plaintiff said that that's not fair because we have the right to choose our members of parliament and that doesn't exclude prisoners. So it's going against the Constitution. And she won her case. So then some prisoners did have the right to vote. So that's one example of representative government that you could talk about. Next is a referendum. So you need to know an example of either a successful referendum or a failed referendum. So we've already talked about them with the double majority requirement. So you need to say either you could pick a successful referendum. So example is 1967 that increased Indigenous rights because previously Indigenous people weren't counted in the census. And weren't counted as like Australian citizens, which is awful. But they had this referendum to say, we want to change that and we want to include them in the Australian census, include them in our population. And that had an overwhelming majority yes vote. I think it was in the 90%, so even in the 60s, you know, a long time ago, but still had a yes vote, which was really sort of a significant change for Indigenous rights. So you could have that as your example and say it shows, you know, the ability of the double majority requirement to pass and like how referendums can be really representative. Or this is what I did, you could pick a failed referendum. So for example, in 1999, the government tried to change the constitution to make us a republic. So no longer having the Queen as a head of state, as a Commonwealth, but to get rid of it and become a republic, sort of like America. But it didn't fail. It did fail, didn't pass in 1999. It didn't get that double majority requirement. So you could pick that and you could say, well, this shows how strict sort of the double majority requirement is, and it's really hard to pass. And you could emphasize on like the sort of strict, unflexible nature of the Constitution, how that's good in protecting the Constitution as well. So there's no better one to do. They'll just ask you for some example of a referendum. It doesn't have to be one or the other, but do make sure you learn one. That is really important. Okay, next is the division of powers. So division of powers, we've already talked about it, right? That you've got residual, concurrent, and exclusive, those different types of lawmaking powers. But what's important is that you need to learn a case that changes the division of powers. So one example is the Brisland case that you might have already learned at school. You might have learned another one, and that's okay. You can learn that instead. But in this case, the effect, I won't go through all the details, but the effect of it was that it gave Parliament more lawmaking powers in something that they didn't originally have. So you would say that expands Commonwealth's lawmaking powers in the division of powers. And before that, it was quite limited to exclusive. So that's one example of what you could do. But as long as it impacts division of powers, then that's okay to talk about. Next is the external affairs power. So this is one that I feel like people often find tricky. I think I did as well in year 12, so don't feel bad if you're still sort of struggling to really get a grasp on it, because it is a bit tricky. And again, something that might come up on the exam because they couldn't ask about it last year. So what you need to know is what is external affairs power? So external affairs power comes under section 51 of the Constitution. It says Commonwealth Parliament has the power to make laws in regards to external affairs. That's like a really broad statement though. And, you know, if you actually look at the Constitution, that's all it says. It just says external affairs and doesn't really explain what that means. So what the High Court has had to do in the past is to decide, well, what does external affairs mean? And it will do that through cases that it hears. So it's eventually decided that includes legislating about international treaties, but it hasn't happened until they've had those cases that have decided that, and the High Court's given meaning to those words in the Constitution, which is really significant. So an international treaty is an agreement that's legally binding between countries. So it can be bilateral, just between two countries, so between Australia and the UK, for example, or it could be multilateral and be between a number of different countries. It might be all the countries in the United Nations, for example. There's sort of no limit on how many countries. But the thing with a treaty, so it's legally binding, but it doesn't become legally binding until it's ratified, which means that Parliament makes a law that says we're going to, commit to implementing the promises of this treaty. Until Parliament does that and they make the law, it's not actually binding. So they have to make sure they do that as soon as they've signed the treaty. But that's international treaties. You also need to know about declarations, but it's sort of not as important as treaties, but do make sure you still covered it. So a declaration, it's the same thing, like an agreement between countries. The only difference is that it's not binding. So it's not maybe as influential as treaties. It might not lead to laws actually changing, but it can lead to a treaty being made. So you might have a declaration, which then leads to a treaty, which then leads to that law being made in Australia. So it still can be influential. A really good example case that I'm assuming most of you have done at school, and again, you don't have to learn this one, you might learn a different one, but the Tasmanian Dams case. So again, I won't go through the full details, but what happened in this is that the Tasmanian government had residual lawmaking power to make a dam. So with residual powers, they're only for states. So Commonwealth Parliament can't intervene, but they did anyway, because they said this dam or the river that was going to become the dam is like protected under a heritage listing, under a treaty. So Commonwealth Parliament sort of intervened in residual areas of lawmaking because of a treaty. So what the High Court decided is that, yes, they do have the power to do that because treaties come under the external affairs power, and sort of expanded the power of Commonwealth lawmaking. So that's a good case to learn. I would recommend it, but there's lots of other ones you can learn out there as well if that's not the one for you. Awesome. That's it for Unit 4 Area Study 1. It's a little bit shorter because it's worth, I think, in your SACs, it would have been worth 40 marks, whereas Area Study 2 is worth 60 marks. So we're going to split this up across the break. So we're going to do half now about courts and lawmaking, and then we're going to talk about law reform in our third block as well. Okay, so the first thing you need to know is, and this sort of gets a bit repetitive and you might feel like you're just talking about this all the time. You probably felt like that during the year, but that's good. If you feel like it's getting repetitive, that means the connection's sort of linking in your brain. So that's good if you're getting that feeling. So what you need to know for the roles of the houses is how it relates to the effectiveness of Parliament making laws. So we talked about the role of, the Senate before, for example. That's just so you could learn what the Senate is, what do they do, whereas here we're talking about how effective they are. So the first thing to know is the effectiveness of the lower house. So the Commonwealth Parliament, that would be the House of Reps or the Legislative Assembly in the Victorian Parliament. So what will affect that is whether we have a majority government or a minority government. So, for example, in the House of Representatives, to get a majority government, you need at least half of the seats. So that would be 76 out of 150. It's just over that halfway mark, right? So to reach a majority government, you have to win more than half of the seats. And what that means is you can have a really efficient and effective government, because if you, let's say if Scott Morrison and his Liberal government have that majority and they all vote yes on all their laws, they'll get through really quickly and really easily. So it can be a really efficient way to make laws. But the downside to that is that they're not going to be properly scrutinized if they're just really quickly passing laws through all the time. But I guess that's the role of the upper house, that they can review those bills if they haven't been made effectively. On the other hand, the minority government is when you don't reach that halfway threshold, you don't reach that 76 out of 150. So what happens then is that in order to reach that halfway point, you have to rely on the support of minor parties and independents. So if it was a Labor government, for example, I think Julia Gillard, when she was Prime Minister, she didn't quite reach that majority. So what she would have done as Prime Minister is relied on the support of the Greens party, maybe some Greens members, some independents as well, that she sort of needed to get to that halfway point. So that can be good, that if you've got not only the Labor Party, but also the Greens in the government, it's sort of a range of different opinions. They can sort of scrutinize the bills and really debate them before they're sort of finalized, which is good that the bills are really effective. They haven't sort of missed anything, but that can take a lot longer and it can be harder to get those bills through, unlike a majority government that just will pass right through. So good to compare them. It's sort of like the strengths of one will be the weakness of the other. So they're really good to sort of put them side by side, I guess, for your own understanding. Then for the upper house, you've got the rubber stamp and hostile upper house. So what rubber stamp means is when in the upper house, you don't need a majority, unlike in the lower house. So for example, if you've got a Liberal government in the lower house, any party can have a majority in the upper house. It doesn't have to be, you could have one Liberal member and all the rest of other parties. It doesn't actually matter. But a rubber stamp is when there is a government majority in the upper house. So again, you don't have to have it, but when there is that government majority in both houses, so if Scott Morrison passes that law through really easily with his majority government, then it gets to the upper house and you've got this rubber stamp Senate where there's a government majority in the upper house too. All those Liberal members will also say yes and pass the bill through. There's no sort of effective debate and the bill just gets passed through really easily. So it's good that it's, again, really efficient and really quick, but it's not as effective and it hasn't been properly scrutinized. On the other hand, a hostile upper house is when you have no government majority, which can be great in getting that debate and discussion and make sure the bills are properly discussed, but same as sort of a minority government, can take a lot longer. You might go really back and forth with amending these bills all the time because there's so much debate and discussion about them. So those are the sort of 4 things you need to know for deciding how effective the upper and lower houses are in Parliament. The next thing is representative government. So we've already talked about this with section 724. The only thing you really need to know is what is representative government. It's when the government represents the people, and that happens through election. So we vote for the people so they can represent us, and that these people that are elected have to listen to the views of the majority. So a good example of this is in the last Commonwealth election, I'm pretty sure, Tony Abbott, our ex-Prime Minister, he's had a really safe seat for a very long time in his electorate. And what happened is, because he's sort of in a safe seat, he didn't want to be too controversial about making laws, didn't want to lose voter support. But he got a lot of questions about climate change and people saying, my concern, as a young person is about climate change. Are you going to listen to my values? Because he should, right? He's their representative and that's what his people are concerned about. And he sort of dismissed it. And what happens then as a result of that, so with Tony Abbott, but it can happen with anyone in any political party as well, is that if you don't listen to the views of the majority about climate change, for example, you can lose your seat, which can be a good thing to make sure that these people are listening to our values and they are being representative no matter what party they come from or wherever we live as well. So that's representative government. Next thing is political pressures. So there's 3 levels of political pressures. So the first one are internal political pressures. So this means within Parliament. So for example, there might be pressures about voting yes or no on a bill. You might have confrontation within a party, so the Labor Party might have disagreements between their members, not just the opposition. There's different ways of voting. So you can vote along party lines, which means that everyone in the same political party votes the same way. So that's sort of stable, it's consistent, there's no surprises. That can be a good thing to do. Or you can have a conscience vote, which is where, we've got a bill that's to say, for example, we're going to extend lockdown. Sorry to use COVID as an example, but let's say Dan Andrews makes a bill that says, we're going to extend lockdown, right? He can either say, let's vote along party lines, let's all vote yes to it, and then it's pretty predictable that it will pass. Or if you've got a conscience vote and you're like a Labor politician, you don't have to agree with Dan Andrews, your leader. You could vote yes or no, and based on your own personal views. But that might be negative in the way that maybe it's not representative because you voted for the Labor Party. So you want to sort of make sure they're all consistent in their values. So good, not one better than the other, but good to sort of compare what you think maybe is more effective. Okay, then we've zoomed out a little bit from Parliament to domestic. So this is all of Australia. So with domestic political pressures, if there's sort of a need for law reform, we'll talk about this more after the next break with law reform, and people want laws to be made, they can sort of have their voice heard by, you can go to a protest, you can make a petition, sign a petition, all these other ways that you can really influence Parliament, put pressure on them to make certain laws. Then we zoom out again. So we go from Parliament, then domestic, Australia, international, worldwide, that things like international treaties can really put pressure on Parliament to make certain laws, which can be a good thing, but also it might mean that it distracts from Australian issues. So we might sign a law, for example, about, let's say maybe like gun control. America's really concerned about gun control, and we say, okay, we'll support you and we'll sign this treaty, but maybe it's not so much an issue in Australia. So it's sort of like, it's great that we're showing international support and involvement, but it might distract from Australian issues, maybe something like preventing bushfires, or I don't know, our COVID situation or something like that. So it can be good, but might be distracting from our issues and interests as well. Okay, another factor linking to Parliament is restrictions on lawmaking. So we've already talked about a lot of these, but it's good to have some examples of how Parliament maybe is less effective because there's restrictions on what they can actually make laws about. So, for example, states can't intervene in exclusive areas of lawmaking. So like I said before, they can't make their own currency or military because they're exclusive powers. States can't intervene with them. Same with other way around. So Commonwealth can't set up an education system because that's a residual power. They can't intervene with express rights. So they can't make a religion as an example because that's an express right. When you do have these conflicts and sort of Parliament goes beyond their restrictions and they do the wrong thing, the High Court can resolve that by applying Section 109 and saying, the state law will become invalid and the Commonwealth law will prevail. Or if it's, just Parliament's legislated on express right, they've done the wrong thing, they can just declare that law to be invalid. The High Court's got a lot of power, so they can be really effective in doing that. So those are some restrictions. Okay, what we're going to talk about now, so we sort of finish with Parliament for the minute, and we're going to spend some time talking about how courts make law. So we've talked about Parliament, how they make law with their bicameral structure and their houses, but now talk about the courts. So the courts are a little bit different. They use the system called doctrine of precedent, and what this means is that decisions that judges have made in past cases will apply to future cases. That's what the doctrine of precedent means. So it's good in that it's really consistent, that you can there's no surprises. You can expect what the judge is going to say based on old cases. But sometimes that can be a little bit too restrictive as well, that judges aren't making new decisions based on modern values, but they're sticking to old stuff instead. So some key Latin words you need to know, and I love using those words because I feel like in the exam they're great to use, that they make you feel really smart using your Latin legal vocab. So great to learn if you can. I'll start off with, and terrible pronunciation, sorry, I feel like my legal teacher always taught me them the wrong way, but as long as you can spell them, that's what's important. But stare decisis is the first one, which means to stand by what has been decided. So what that means is, like I said, a judge will make a decision in an old case and then it will be applied in this future case. So the judge stands by that old decision and doesn't change it. So that's what that means. It's the key principle of the principle of justice. Sorry, doctrine precedent. I don't know why I said principle of justice. That must have been ringing in my head from unit 3 before, but key principle of the doctrine of precedent. Then we have ratio decidendi, which is the reason for the decision. So that's the binding part of a judgment. So if you say, for example, I'm going to interpret the word book to mean this, the judge says that's my decision about how to interpret the word book, this is my definition. That becomes binding, the actual definition, but also the reason. Why have you interpreted that that's what the word book means, So that will be really influential for judges to follow in future. Then the third one is obiter dictum, which is a by the way statement. So what that means is it's not binding, it's not the reason for the decision, like the ratio decidendi, but it is a really influential statement that might help in future cases. So you might be reading the past judgment and think, oh, the judge also mentioned that it's good to think about this other type of book in case it comes up in a future case. So you don't have to follow it, but again, it can be really influential. So those are some key terms. It's really important that you do get them down so you can use them in your answers. So persuasive and binding precedent. So a precedent will be binding on a court, on a judge, when it's made by a higher court in the same hierarchy. So for example, if I'm in the county court in Victoria, the Supreme Court in Victoria and the Court of Appeal will be binding, and the High Court will be binding on me as well. Whereas I don't have to listen to decisions made in the magistrate's court, because that is lower in the court hierarchy. So if it's binding, you have to follow it, and you sort of can't get out of following it. We'll talk about some ways that they can do that though. If it's not binding, so if it's from a lower court or maybe a court in a different hierarchy, so for example, if it was like the New South Wales Supreme Court, then that becomes persuasive. So persuasive is where you don't have to follow it, but it can be really influential in making your decision. You might decide to follow the precedent anyway. It really depends on the case and the type of judge that you have. So just to finish doctrine and precedent, we've got some methods of how to avoid following precedent. So if you're stuck following a precedent that's really old and outdated and you think it's unfair, even though it's binding, there are some ways you can get out of it. So the least effective way, which I'll start with, is disapproving. So when you disapprove of a precedent, you as a judge would say, I think this precedent's outdated. I think I shouldn't have to follow it in this case. I think it's a bit unfair, but you still have to approve. You still have to follow it anyway. So you can express your dissatisfaction, but it doesn't actually get you out of following the decision. Then the other three are more effective. So distinguishing is when you can say, I don't want to follow this precedent because the facts of the case aren't similar enough, because that wouldn't be fair, right? To follow the decision of a judge. For example, maybe one case is a defamation case, one's a negligence case. They're different types of civil law, so you shouldn't have to use the same precedent in both of them. So the judge could distinguish the facts of the case to get out of following it, and they'd make a new precedent instead. Then there's also reversing. So reversing and overruling are quite similar, but I'll try to explain the difference. So reversing is when Superior Court reverses the precedent of a lower court, but it's the same case on appeal. So it's moved up the court hierarchy, and the higher court reverses the first decision made by the lower court in the same case. Overruling is the same thing, except it's not the same case on appeal, but it's a different case at a later time. So the Supreme Court gets rid of a decision that the county court made in the 1980s, for example. Different case, different time, but they both get rid of an old decision and make a new precedent instead. So you can see with this that even though, you know, the doctrine and precedent is really binding and restrictive, there are some ways that it is a bit more flexible. So you want to sort of have both those strengths and weaknesses in your answers. Next thing is statutory interpretation. So what this means is judges have the ability to interpret legislation and give meaning to the words. So you need to know the reasons why you have to do it, and then the effects of it as well. So the reason why a judge might have to interpret the word, so for example, the word book, what does that mean? Is if Parliament in their law didn't maybe give a definition, maybe they did give a definition, but it's a bit ambiguous, or it doesn't make sense, or there's two different definitions, but there's some reason that means the judge doesn't have a clear definition of a word and they need to give their own meaning to this word in the legislation. So that could be some reasons why. Then the effects of that, of saying this is how I'm going to define the word book, is that it gives meaning to that word, and that becomes binding on the parties, and it becomes a precedent to follow in the future. But also it can either restrict or expand the meaning. So for example, some of you might have learned this year or last year, like the studded belt case, which is where there was a case where there was a studded belt, like an accessory that you would wear, used in I think it was an assault case. I can't remember all the details, but the whole dilemma is this a weapon, right? A studded belt, you know, maybe anything could be a weapon. So in that case, even if you ignore the actual decision, if I'm the judge and I have to interpret the word weapon, I could either give a really, really specific narrow definition of a weapon. I could say these three things, like a knife or maybe some other things, they're weapons and that's it, nothing else. Or I could give a really broad and expanded meaning. So I could say anything that can be used with force against another person, that's a weapon. So then my pen could be a weapon, right? If I could use it with force against another person. So that's an effect, that either a really narrow restricted meaning or really broad expanded one. So the judge has a lot of power over the ways to interpret these words. So doctrine and precedent comes up again. We've already talked about it, but think about how it affects the ability of courts to make law. So it's a bit, it creates consistency because they're following the same decisions. It's flexible because you can distinguish the facts, for example, but maybe if it's binding and you can't get out of it, that's a bit unfair for judges. So some strengths and weaknesses that you can think about as well. Next is judicial conservatism. So judicial conservatism is where you have a judge making a decision that's really conservative in the fact that they only look at the law and like the legislation and the precedent, and that's it. They don't think about what's going on in the media, what the population wants, any other sort of social or political factors. They just look at the law and the words and what they mean. So that can be good in that it creates consistency and predictability, I guess, but also that's a negative thing, that maybe that's really unfair, that if you've got a judge interpreting words without thinking about sort of social context, maybe it's a really unfair decision, which might cause outrage from the people, and then maybe Parliament has to get involved and get rid of the decision. So it's not always bad, but it can have some negative side effects if you're a conservative judge. On the other hand, judicial activism is when a judge isn't conservative, they're more active and create sort of more controversial laws. So they will consider those other social political factors in deciding their case, which in a way some people might say is bad, because judges aren't elected, so they don't have any responsibility to be representative of the people, right? So they should technically just follow the law, but it can be good in making sure laws are representative, common law. It might mean Parliament gets involved, either they support it or they might abrogate it. So an example is the Mabo case that I'm sure lots of you have heard about in 1992, when the High Court established the principle of native title, which gives more land rights to Indigenous people. That was sort of an example of judicial activism that was a bit controversial, and they were considering other factors about like Indigenous rights and history and what the people wanted. But Parliament sort of were very happy with it, that they supported the decision and turned it into law as well. So that's an example of how judicial activism can be really effective. Okay, another factor is cost and time. So cost and time factors just means that the courts can only make law if they have someone that's come to them to make laws. Let's say for me, I noticed that Parliament has like done something wrong and I want to take it to the High Court, I probably wouldn't go to the High Court, because it takes a lot of time to, go travel to Canberra and have to probably take time off uni or take time off work. Probably couldn't afford it as a uni student as well, all those legal fees and travel fees, that even if I'm the only person that can go to the court and wants to go to the court, that's like a barrier for me. So if I can't get to the court, it means that they don't have anyone to initiate this case, and they can't actually make a new precedent or apply precedents as well. So that's important to think about. The next one is requirement for standing. So requirement for standing means, even if I want to take a case to the court, I can only do that if I have special interest in a case, if I have standing. So what that means is I have to be directly affected by an issue. So let's say, for example, Parliament made a law that banned Islam as a religion, and I see that happens. I'm like, that's wrong. That's beyond their lawmaking powers. They've gone against freedom of religion. I want to do something about it. If I, have the money and all the time to go to the High Court, I wouldn't have standing to go to this case. I wouldn't be allowed to have this case because, like, as a non-Muslim person, I'm not directly affected by the issues, right? So you have to be directly affected by the issue at hand in some way, whether you're like a religious leader or you do follow this religion, or in any other case, you do have that special interest. So it's good in a way that it narrows down the cases that they're hearing, like they're only hearing really serious cases of people who've been affected by stuff, but also it's a weakness that people maybe like me that are generally, passionate about these things, they can't go to the courts. So good and bad things about requirement for standing. Okay, last little bit I think in this section is you learn about Parliament, we've learned about courts, and now we're bringing them together. So some things to think about is that Parliament is the supreme lawmaking body, so they've got a lot more power than courts to make laws, which is significant, and a way that they can do that is through abrogation. So they can abrogate court-made laws in that, if they think it's too controversial, they can get rid of it and override it. So that's a lot of power that they have as supreme lawmaker. Also, courts can influence Parliament by through codification. So they might make, like the Marlborough case, a bit of a controversial decision, but it gets Parliament's attention. They can support that law, like in the Marlborough case. So there are a few different ways that they interact together. So I think, that's it for the content little block. I've got a really quick activity before we head off for your break. I'm just gonna get something ready. Okay, what I've done is I've changed the chat settings, so you should be able to answer this question in the chat and see each other's answers as a good way to collaborate together. But I've got this question, and I would love for you to answer in the chat a yes or no, and just a really brief, doesn't need to be a full 3-mark answer, but your response. So I'll read it out to you. A referendum proposal was voted on by the electors of Australia. 56% of all voters in Australia voted in favour of the proposal, and the majority of voters in all states except Victoria, Tasmania and New South Wales voted in favour of the proposal. Was the referendum passed? Justify your answer. So I'm going to go through a sample answer, but I'm going to give you about 1 or 2 minutes just to have a think about it. Add in the chat yes or no and your reason. And do think of, maybe get inspiration from others, but don't feel discouraged by the answers. If you disagree with someone, go for it. That's good that we can have a bit of a debate about what's going on. So have a think about it. And awesome. So good work, Bailey. You've put something in the chat, and keep it coming for the next minute. And then I'll talk about a sample answer. Awesome. Thanks, Phoebe. Awesome. Patrick, Jara, good work, everyone. Daniel, Kevin, Karen. Awesome. Keep them coming, but I'm going to start talking about the sample answer, but you guys are right on track with all of this, with your answers. So this is awesome. So keep it coming. And I'm talking about the sample answer. So this sample answer that I have written, and you might approach it in a different way, but hopefully to give you an idea of what you would need to do to get 3 marks. So first of all, just say yes or no straight away. So it makes it really easy for the examiner just to say, well, what's your actual answer? Which you've all done. You've all said straight away, no, just great. So this referendum would not have passed. Then my justification. So I've got sort of my reasoning here. So first of all, 56% of all voters in Australia voted yes. So this satisfies the first element of the double majority requirement outlined in section 128 of the Australian Constitution. So first of all, it's like, well, the first bit has been satisfied. So you can say that you realize that. But then what you are all doing a fantastic job in noticing is that, however, because only 3 out of 6 states voted in favour of the proposal rather than 4 out of 6, the double majority requirement has not been satisfied. So you need, remember, like I said, you need 4 out of 6. So it hasn't been satisfied, and thus the referendum would not have passed. So it's not too long. If you've got those 4.5 minutes to answer this, I think it would be plenty of time to say, no, here's my reason, therefore it would not have passed. So have another look in the chat. Oh, awesome work, everyone. I think almost everyone said no and given your reasoning. So that is excellent. Good work, everyone. All right, I'm going to jump over to Mentimeter before we have our break, our second break. So give me 1 moment while I share my screen again. But that's awesome work, everyone. I can see you're really understanding the content. So that is fabulous. Okay, so I'll answer maybe 2 or 3 questions before we go to our next break. So any tips to complete the exam within the time limit? That is a great question. There's no sort of right way to sort of approach the exam. The way I did it is I sort of went in with like a plan of action, I guess. I went in there and I decided I would start off with my favorite question, whatever I thought was the easiest. So it might be a 1-mark question, might be 6 marks, but a question that, you see in reading time and you're like, yes, I love it, right? It's really good to start with a question like that, no matter how big or small it is, that it'll sort of like hype you up for the exam a little bit. I think that if you can answer a question that you're really confident with and you enjoy doing, that's a good way to set you up. Then maybe getting a big question out of the way. So like I said before, maybe not the 10-marker, but maybe, for example, the 8-mark question. So you can get a really big chunk out of the way. But again, self-control is really important to make sure you're sticking to the time limit. So have that 1.5 minutes per mark in your head to try to stick to it. Then other than that, I would have done that. My favorite question, the 8-mark question, and then I went in order from start to end. You might prefer just to go start to end. Maybe it's a bit easier to keep track of time. Another good way to stay in the time limit is to think, okay, I've got 4 minutes to do this question. So right now it's 12:05. So you could write up for question 1. I have to be finished by 12:09 if I've got 4 minutes. That way you get to 12:09, keep going, and you can really stay on top of the time limit. So that would be my advice for staying in the time limit. Rakaya, any other advice?
Yeah, I just wanted to say, for me personally, I just started with the most easiest questions and got all of them done because I don't want to miss any marks that I would have got otherwise if I ran out of time. And also I put, like, during the reading times, I put my pencils in the middle of the papers that I was going to go back to as soon as possible. So that made it easy for me. And also, while you're writing the answers to those short answer questions, you will remember content that you have forgotten about, and then you can go back to the longer questions. So that's my advice, and definitely keep that in mind. And also, you only need the points according to the number of marks you get. If there's 4 marker, you only need 4. You don't need to put 5, 6 marks because you won't get marks for them anyways.
Yeah. Awesome. Thanks, Raquel. Yeah, that is really, really good advice. Sort of, guess again, like self-constraint, you might have 10 million things to say about section 109, but if it's 2 marks, just say 2 things and then keep going. Awesome. So I'm going to mark that as answered. What should we do to study before completing practice papers? A good way to do it is sort of a really good technique that I used a little bit in year 12, but it depends again on how you learn. But in terms of like learning content before doing questions, there's a really good technique called blurting, which sounds a bit weird, but it's when you get like a blank piece of paper like this, and you might write at the top, okay, like section 109 of the Constitution. And what you do is you maybe like have a skim read through your notes, or maybe go into it blind and just go into it and write down for 3 minutes or something, everything you can think of to do a section 109. Then what's really important is that don't just do that, but go back over your notes and see what you've missed, and really then maybe try again and see what content you've missed. So that's one way that I did it. Other ways, like explaining it to a friend, or if you don't have a friend to explain it to, maybe because in COVID and stuff, family member if they're willing, a pet if you have one. When I didn't want to do that, because I know that doesn't work for everyone, a really good thing to do is just get your phone or some device and do a voice recording of just you like talking through the content, and that way you can always listen back to it as well. That's another good way to do it. So rote learning can help if you're a bit more of an audio learner, speaking it, recording it to yourself. Those are probably my best things. Maybe go through the study design as well to make sure you haven't missed anything accidentally. But Raquel, any other advice about in terms of content, how you would study? Oh.
Yeah, I think the way I studied was you have a lot of notes. You have the PowerPoints, you have the book. Can you hear me okay?
Yeah, sorry, you're frozen for a little. Oh no, I think Raquel has gone. Okay, hopefully she'll be back soon and she can answer the questions. Oh, she's back. 1 second. Raquel, are you back?
Yes, I'm back. I'm so sorry.
No, that's all right. Sorry, what were you going to say?
I was going to say you have a lot of notes. So you have your textbooks and you have your PowerPoints and everything. So what I did was I just put everything that I knew in a A4 paper, so cramped it all in A4 paper. So that's what I remember, and I kept reading over and over it, and I treated the practice exams like an actual exam. So just time yourself while you're doing it as well, and just that's it. Don't stress about it too much. Just do your best and do as much content as you know.
Yeah. Awesome. That's super helpful. All right, let's maybe do one more and then we'll head into our break. So is it important to use cases and legislation as much as possible in the exam, or only when questions asked for it? So for those of you who don't know, the way the exam's sort of laid out is that section A are like all short answer questions with some hypothetical like case scenarios. So there might be one like, oh, this year 12 student bought a dress and wants to go to CAV. We'll have a question like that later that we'll look at. When it gives you source material in those section A questions, always use them. So say, Raquel would be able to go to CAV and this would help her achieve access, but maybe she should consider cost factors. Is it a helpful way to save money or something? So when it gives it to you in section A, definitely, but only sort of, you can do it just when it asks for you. Then in section B, which all of section B is source material, you have to use in every question. So there's some questions where it might give you like a bit of legislation or a case, or something from the news in section B. You might get a question that's like, outline the role of media in law reform. Even though it hasn't asked you to use a case, you still have to use it. In section B, you've got to use it the whole way through. That's a really easy way to lose marks if you forget to do that. So section B, definitely the whole way through. Section A, not so much, only really when they ask for it. But if you've got your own other like cases and legislation, it's good to use to show your knowledge, but as long as it's not distracting from your actual argument or answer. So only use them to support yourself rather than being the focus of your answer when it hasn't really asked you to do that. So yeah, that would be my response. Any other thoughts, Raquel, on that? Or is that sort of everything for cases? Sorry, can you hear me? Just checking.
Yeah, you've covered it well.
Okay, great. All right, I'll say that's answered, and then let's head back over to our slides. I think we're going to have another bit of a break now. So let me just have a look at time. It's 2:11 now. We'll come back at 12:20 is when we'll come back. So another 10 minutes of our break. So again, like refresh, have a stretch, we'll play some music, you can relax to, get a drink, go to the toilet, whatever you need to do. And we'll be back at 12:20 to finish off our last break. You're all doing so well, and we're nearly at the end. So thank you for sticking along with us. But all right, I'm going to play a UBS video to lead us into the break, and we'll see you all again at 12:20.
Hi, my name's Sahaj and I'm an investment banking analyst here at UBS. So basically, I work with the team to advise our clients on making important decisions, such as how to use their resources most efficiently, how to grow the business moving forward. Is it a good time to sell a part of the business? Is it a good time to maybe buy another business? So we help them with these decisions. What I've particularly enjoyed in my short time here at UBS so far is the opportunity to work for some pretty big companies that I'm sure would all deal with on a daily basis. So I think it's really cool to be a part of something like that. So during VCE, I particularly enjoyed math and commerce subjects. So I studied maths methods and specialist maths. And for the commerce subjects, I did accounting and economics. I was really interested by what I learned during VCE, so I wanted to pursue it further. And that's why I studied commerce at the University of Melbourne. That's where I learned about finance. I involved myself in a lot of university societies, and that sort of sparked my interest in investment banking and the work that we do here at UBS. Some additional advice from my end is always to be curious and to not settle for things. And whether that's with your career path or what you might want to study in the future, make sure that you're always trying new things and opening your minds to everything that's out there. I guess VC is just one chapter of what can be a pretty long story. So whether you perform exceptionally well or not in a couple of months' time, remember that you still have the rest of that story to write. My advice to myself, if I was doing VC again, would most definitely be to zoom out and always take a look at the bigger picture. You've probably heard something like this before, but high school's a very unique experience, I think. It's definitely one of the last opportunities for you to spend almost every day with a majority of your friends all around you. Make sure not to get so consumed by VC that you forget about what's otherwise a really special year in your lives. Don't forget about your passions, your development as a person. So trust that you've put in all the hard work for your VC exams, give it your best shot, but look forward to the life ahead and everything else that's exciting in your lives.
So procrastination is probably one of the things that makes us feel the worst. Like when we know that we're not doing something that we should be doing, we feel terrible. You hear people talk about the fact that, oh, I'm just procrastinating, I'm not getting started, and how down and how flat that makes us feel. By the end of this video, you will have a different way of thinking about, a different way of feeling about procrastination, which is totally normal and totally human. But when you think about it from this angle, it changes your relationship to it. So really important to remember is that fact that procrastination is actually totally human. We all do it, and getting awareness of what's going on in our head when we're doing it can really help us to have some agency in how we deal with it. So if you think about it, it's not actually the procrastination itself that makes us feel bad. It's actually the fact that we beat ourselves up for procrastinating that makes us feel bad. We are all human, we all procrastinate. It's the degree to which we punish ourselves for procrastinating that has us feel horrible. And when this happens, we kind of redirect our attention to procrastinating and how bad we are for procrastinating, and we actually lose sight of the thing that we should be working on. In many ways, we self-sabotage. Like, we get so focused on beating ourselves up for procrastinating that we literally spend that energy and don't give it to the thing that we actually need to be doing. And unfortunately, once we go down that negative path, our minds are kind of hardwired to loop in that negativity. which completely distracts us from what we should be doing. And so we actually send ourselves down a path where we actually don't get the results that we want. What I would love you to leave this with is that if you can acknowledge this mechanism and how this plays out in your life, literally, that just having that self-awareness can shift your relationship for how this works out in your life. Because when you can see that you're focusing on the fact that you're procrastinating, which is distracting you from what you should really be doing, something shifts there. I really hope this helps. Let me know.
All right, welcome back everyone. 12:21 now, so we're gonna get back into it.
So procrastination is
sorry. All right, there we go. We're gonna finish off. So we've got another 20 minutes before the end of our session today. So we're going to finish off the content. We've only got a little chunk to go about law reform, and then we're going to spend some time answering more questions and going through some study advice and exam advice as well, and practice questions, which will hopefully help you. So let's get back into it and keep these questions coming on Mentimeter, because I'll try to leave as much time as we can to answer those questions, because I know that might be really helpful. Okay, so the first bit to learn law reform, before you learn about what it is and how effective it is and how to implement it, it's important to know why. Why does law need to change, and why does Parliament need to update them? So these are all the possible reasons to know for law reform. So you don't need to know all of them, but it's good to have some examples if you can. So for example, changes in beliefs, values, and attitudes. So what that means is that as people's values change over time, the law should change with them as well. So the example that I used before with same-sex marriage is that when the Marriage Act was made in the 60s, I think that might be a bit off, but when it was made, the views of the majority was probably anti-same-sex marriage. Now you get to 2017, when the law was reformed and updated, values have changed over time, so it's important that Parliament reflects those changes in the law. So they measured the views of the majority by having that postal vote. I don't know if you guys remember, but so do you support this change, yes or no? And that helped Parliament to decide whether or not to change the law. So as values change, law should change over time as well. Also things like economic changes. So as we got into the pandemic and COVID and everyone was working from home and a lot of people lost work, it's important that the government responded to that economic condition. So for example, they implemented ways for people to still, have financial support in the time of economic crisis. So lots of other ones here, but those are some main ones that you might want to use as your examples. Now we're going to talk about different ways that people can influence the law. So I talked about petitions and demonstrations before as examples of domestic pressures, political pressures, but also that, they're a great way to influence law reform directly, just as an everyday person. So, as me, just a normal person, I'm not a member of Parliament, I'm not a judge, I'm not a lawyer, just an everyday person that might be really interested in the law. Same with all of you as well. So with petitions, they only need to be signed by one person, which is awesome. That if you wanted to, you could make a petition online for free. You could sign it yourself and send it to Parliament, and they'd have to look at it. So probably wouldn't be successful, but it's pretty easy to set up and doesn't need a whole lot of support in order to be sent to Parliament. So some strengths: that it's cheap and it's simple. You could set one up in 5 minutes probably online, or you could have a printed version if you prefer. It's more likely to be successful, of course, the more support that you get. And it's good to spread awareness by getting people to sign petitions and share them with their friends to become aware about social issues. Some weaknesses: people don't tend to not like to share personal information, on the internet or on a written document about, maybe their postcode or their email or phone number, that maybe they feel like their privacy is being invaded. So that might detract some people that don't want to sign petitions. Also, even if you've got, let's say you got 20 million signatures on a petition, nearly every person in Australia, which would be pretty impressive, but even if that happened, you send it to Parliament, they still have no obligation to actually adopt the suggestion. So that seems pretty unfair if you get such a successful petition, all this community support, but it's not actually taken on by Parliament. So there's no obligation for them to accept any suggestions. Also, if you've got conflicting petitions, that can change the effectiveness. So you might have, for example, one petition that says, we want, our VCE students back at school for term 4. Then you might have another one that says, no, keep them at home for their safety. So even if they're really strong petitions, because they disagree with each other, Parliament's like, well, we don't really know which one to choose, so we're not going to choose either of them, and we're not going to change the law. So that can weaken the effectiveness of a petition. Next is demonstrations. So demonstrations are another good way to show support, try to change the law, and raise social awareness as well. So demonstrations, or like protests, you might call them as well, where you show up to an event, you show your support of a social issue to try to get Parliament to change the law. Sometimes can be great, sometimes not so effective as well. We've seen a lot of them, especially over COVID as well, a lot of protests that because when protests become inconvenient or they become violent, they're much less effective. So the recent example of construction workers protesting in the city, even if they've got a really strong cause and a lot of support, and they're really trying to have an effective outcome, because a lot of them have been quite violent, of like assaulting animals and assaulting police officers, Parliament's not going to listen to them when they're causing that violence and inconvenience as well. During COVID, that it's technically illegal, all of them being out there. So that applies to those recent protests, but lots of other ones as well. For example, the Black Lives Matter protest last year, because it had, might have had a great issue that it was talking about and lots of support, but because it happened in between lockdowns and it sort of was also against the law, it really sort of minimize the likeliness of any actual law reform being implemented. So demonstrations can be great, but also they're quite hard to organize. Petition takes 2 seconds to sign one, but with a demonstration, you actually have to go and show up on the day, and you can't always rely on people to do that. So again, strengths and weaknesses to both of them. Next is the use of the courts. So this is a bit different to petition demonstration, but can be just as effective. When, like in the Marlborough case, an everyday person like Eddie Marlborough goes to the courts to try to change the law based on what they're aware about with social issues and legislative issues. So a good way that this is effective is that judges are independent from Parliament, so there's sort of no bias there, no political tensions or anything. Especially at the High Court, they've got a lot of power in law reform because they can influence Parliament's law and, declare it to be invalid or inconsistent or something like that. Also, they can, it might lead to Parliament codifying the law. So with the Marlborough case, how it led to legislation that implemented the decision about native title. Some weaknesses though as well. So think about the difference between signing a petition at home on your phone, takes 2 seconds, versus taking a case to the High Court. Quite different sort of ends of the spectrum. Just as effective, but it takes a lot of time and money, like we've already talked about. So definitely some weaknesses there that, and you have to have standing to go to the courts and all those other things that we've already talked about that are definitely important to think about. Okay, next, the role of the media in law reform. So media can be really effective in influencing the laws that Parliament makes and changes. So you need to know about traditional media and social media as well. So traditional media are things like newspapers, news programs like ABC, and the radio as well. And they can be really influential in sort of raising awareness about issues, offering a platform to debate, maybe interview politicians or things like that, so they can present their stance on law reform to make you more informed as well, and maybe influence Parliament. If it's really all in the news, this issue that's going on, Parliament probably has to respond to it. So that's one thing to think about, traditional media. Then social media as well is quite similar, that it can raise awareness, create interest in these issues, might be a way to spread awareness about a protest that's happening, or you can have a link to a petition in your Facebook profile or something. Some weaknesses though is that sometimes social media, you get things like fake news and you get inaccurate information that you sort of can't trust everything you see. Whereas if you're reading the newspaper, it's much more reliable than social media. It might still have bias, but still social media, not always reliable. So you've got to be really careful about the stuff that you're reading. Okay, now we're going to talk about the role of the VLRC and law reform. So the VLRC stands for Victorian Law Reform Commission. And what happens is Parliament makes law. So they'll have to decide, okay, there's this issue. Do we change the law? Do we make a new law? What do we do? And they have to make up their mind about law reform. Sometimes they're too busy to do that. Parliament doesn't actually sit many days in the year, so they don't always have time to decide on these things. So what they might do is they might say, so Victorian government might say, hey, VLRC, we want you to investigate whether or not we should change the education system. Should we create a new system instead of VCE? That hasn't actually happened, but just as a hypothetical example, they might say that to the VLRC. Then the VLRC gets the instructions from government. They go away and they research the issue. So they might talk to teachers who would be experts, or people from VCAR, for example, who are experts about the VCE curriculum. They might talk to students as well who are really impacted, and they get a range of different opinions from experts and just everyday people, maybe parents as well would be everyday people. Gather that research over several months, maybe even a year or longer. Once they've done that research, they'll report back to Parliament about the decision that they've made. So their main roles are to inquire and investigate, but then also monitor law reform about, Parliament said they would change the education system, but they haven't done it yet. So we need to keep a check, make sure they're doing the right thing. And then education, just to educate them, maybe educate students like you, studying about the VLRC, but also just everyday people so they can be aware about projects that are going on at the time. So I'm not going to, one other thing about the VLRC, sorry, before I continue, is you have to know an example. So I'm not going to give you one because, again, depends on your school. You all would have learned different ones. So I don't want to, teach you ones that you haven't done at school, but make sure you do have an example. There'll be lots in, if you have a class textbook, or you can, if you don't have access to anything like that your teacher has, if your teacher hasn't given you anything, just go on the VLRC website and they have a list of all their recent projects. Doesn't have to be successful, but anything from 2017 onwards that the VLRC has done, you can use as your example. So would recommend going on their website. It's free, it's easy, good way to find that information. Okay, nearly at the end of the content. So thank you for sticking around and following along. You're doing an awesome job. With parliamentary committees and royal commissions, a lot of you already know this, but you only have to learn one. So don't learn both, because that's, time you could be using on other stuff, but learn either parliamentary committees or a royal commission, not both of them, one. So questions will always say, and I'll show you one later, the role of a parliamentary committee or a royal commission in changing the law. So I'm not going to teach them to you at the moment, so we can look at, look at your questions and look at some practice questions as well, but emphasis on making sure you understand their purpose, processes, strengths, weaknesses, an example. Same thing, just go on the website. So you might go on like the parliamentary committee website, look at recent projects from 2017 onwards, and you can just pick one to learn as your example. They're pretty much the same as the VLRC, same roles and processes. The main difference is with parliamentary committees. They're all, so VLRC is independent from Parliament, but the parliamentary committee members are all members of Parliament. So they'll come from different political parties. So that might be a weakness, that they might have political bias, and, they might say no to a certain law just because of political reasons or because their leaders told them to. So that might be a weakness, but otherwise they're pretty much the same as the VLRC, but I'll leave that up to you to decide what one you want to do. And you can always do research on their website about their role as well. Okay, this is the last bit of content. So we've done nearly a whole year's of content so far, so good work, everyone. All I'll say about this is, so you've learnt about Parliament, courts, how they make law, how people influence law reform, and then this brings it all together. So it's not really any new content, it's just thinking about it in a different way, about how Parliament and the courts respond to law reform. So how well do they do implementing law reform? So you might say, for example, Parliament does a good job because they're elected, so they can be representative in lawmaking, and they're supreme lawmaking body, so they can, if there's a petition and they want to implement the request, they can do it within a week or something, right? It might be really quick, that straight away, they don't have to wait for anything like the courts, they can just straight away implement the law. Whereas the courts have to wait for someone to bring a case to them before they can do that, so that can take a bit longer. Some other things, Parliament can investigate the need for law reform through the VLRC and parliamentary committee or royal commissions as well. Judges also have a lot of power that, they can be really activists because they don't have to worry about losing voters because they're not elected. And they also, especially the High Court, can declare Parliament's law to be invalid. They've gone beyond their lawmaking power. So that is really, really significant. Cool, that's the end of the content. So I am going to jump over again to Mentimeter. We're going to come back to the Q&A, but for now, what I've got is a poll. Just let me find it. I think it was back here. No, sorry, let me find it. about law reform. Okay, here, awesome. So this is a question I'd love for you guys to answer. So, and there's no right answer at all, but what I want to know is, what do you think is the best method that individuals can use to successfully influence law reform? So out of the three options, we've got petitions, demonstrations, and the courts. Or you might talk about social media as well. There's no right answer at all, but I'm really interested in what you guys think. So we've got 2 answers saying the courts. Awesome. And feel free to go against the crowd, and you might want to say something else as well. Cool. Demonstrations, petitions, since they're tabled in Parliament and demonstrations aren't. That's a really good point. Petitions, demonstrations, media, social media. Yeah, petitions can be, social media can be a good way to share petitions and really spread awareness. Demonstrations, yeah, without violence. So it really depends on the type of demonstration. Yeah, new cases. So yeah, courts can be a good way. This is awesome, you guys. These are really good reasons and good ones that you've picked as well. Can be spread easily. Awesome. I'm happy with that. I think you guys have understood that really well. And there's no right answer. So, I'm not going to say some of you are wrong, because there's no right answer at all. It just depends on what you think are the personal strengths and weaknesses of all of them. Awesome. Good work, everyone. So what we're going to do now, I'm going to come back to our presentation. We're going to give you some study tips before we look at some questions. So I'm going to take you through some study tips, and then I'll ask Rakay if you've got any final advice for them all as well, because you've had some awesome advice so far. So just this sort of in general study advice, so this can apply to any subject really, but especially legal, to of course practice as much as you can. It is tricky having, some of you will have between 4 to 6 subjects, even having 4 can be really a lot to manage. So it's hard to juggle it, but, making a schedule even so you can sort of alternate the subjects you're focusing on. I think during swap back in the holidays, I studied based on my class timetable. So I would have had 3 different subjects a day or something based on my timetable. That way you're not neglecting any subjects, and you can sort of get into a good routine. So you're up early enough and you're not studying all the way into the night. So keep working hard, nearly at the end. So just a little bit more to go, and it'll be worth it once you get to those. For all of you in year 12, at least, I know some of you might be in year 11 doing 3, 4, but get to those summer holidays before uni or work or whatever you're doing, and just to relax. So a few months of hard work, it'll be really worth it in the end, I promise. So go through, look at the study design, the list of topics, and go through them, maybe have a checklist of what you've covered, what you haven't, so you haven't missed anything. Also, share the load to get someone to help you, whether, like I said, a friend, a sibling, to study together, or even if you've got a parent who's got no idea about any of this content, you can teach them about it. Or again, like I said, you can have a voice message and teach it to yourself as well and listen back over it. Take breaks. So something like the Pomodoro technique, where maybe you can do 25 minutes and 5-minute break, or 50 minutes and a 10-minute break. But that way, you're still refreshing and you're not going to burn out, because that's the worst thing that could happen, is you burn out before the exam. We don't want that to happen. I'll have some more specific legal advice, but Rakay, do you have any sort of general studying advice? Anything that we haven't talked about?
Yeah, I think what you've shared is really good. And also there's a lot of questions about, I'm going into more specifically legal advice, but how do you remember what you need to remember for the exam? And it works for every subject too. I think making a story out of it really helped me. For example, fairness, equality, and access. I will just say Alexis something, so that each letter stands for something, and make a story out of it. And that's what I remember too. So if that helps you, feel free to do that, or whatever weird method that you need to do to remember the content.
Yeah, awesome. Yeah, that's super helpful. Just make sure you're on top of it all, and you want to sort of make it as easy as you can for yourself as well, that you don't burn out, and you're on top of it as well. Thanks, Rakay. That's super helpful. What we can do now is go on Mentimeter, and just before we look at some more specific exam questions, so I'm going to go through here. We've talked about this. Interesting. We've got 2 different things in there. Let's see. To sort of make we're going to talk about some like feedback from today before we finish and before we look at practice questions. So let us know how you're feeling. Hopefully you're feeling more confident from how you said about a 5 or 6 at the start. Oh, that's awesome. You guys are feeling great. We really hope it's give you a bit of confidence, and reassured. Like, you guys are doing such a good job from what we can see, which is really wonderful. So those are great words. I'm glad you guys are feeling good about that. Sorry. Okay. And also, I think to do a bit of a confidence check-in as well. We're going to save that for the, we might save that for the end, actually. So, you can, 8.5, awesome. That's already much higher than it was before. So you can start answering that if you want. All right, what would you now come back, into my slides. We just wanted to mention, and Ricky, you might want to talk a bit more about this as well, but some upcoming stuff. So we haven't finished with our exam revision series. So it'd be awesome if you guys, if you've got any other subjects that you haven't been to any revision series yet, definitely recommend checking them out the rest of this week. Would be really helpful. Hopefully, if today's been helpful, there's some other sessions so you can book them through Eventee. And then we've coming up in October got an exam hack series as well. Ricky, did you want to talk about maybe this or anything else that Skyline's offering?
Sure, I've just sent the link in the chat. Feel free to click on it. So Leah does great jobs in terms of helping students not feel really panicked for exams, because it is really stressful. So if you wanted to attend, just click on that link and you'll have more information there.
Awesome. Okay, and also we've got, I think I mentioned just a final feedback survey about today and whether or not it was helpful for you. We would really love to hear what went well, what you enjoyed, any feedback you have, any constructive feedback you have as well. That would be really important. So awesome. Ricky has put that in the chat. I might give you just a minute now, since we're a little bit ahead of schedule anyway. I might just give you a silent minute to have a go filling that out, because we'd love to do it before you leave. That's really important to make sure you get it done. So I'll give you a minute just to fill that out, and then we will keep going in a minute or two. And once you've filled it out, maybe think about, are there any other questions you want to ask on Mentimeter? Because I'll answer some more, or maybe upvote any questions that you want me to answer as well.
I'll also send a link to the presentation a bit later on so you can have access to it. And just feel free to go on Eventee and register for other subjects that we're offering as well. We have psychology at 1:30 today, if anyone's doing psychology. And we've also got some sessions tomorrow and Friday. So feel free to go on Eventee, check them out, and register for the subjects you are interested in, and they'll be really helpful for you too. And you also have access to their recordings and their presentations for your reference in the future when you're studying for the exam.
Awesome. I'll just give everyone maybe another 30 seconds to fill that out, and then we will keep going with some more specific exam advice. All right, we might keep going. Hopefully that's enough time, but do keep that link so you do make sure you fill that out, because that will be really, really helpful for us to get that feedback. But otherwise, let's keep going. So some questions about the exam specifically. So I've already talked a little bit about, things about timing and maybe how to approach it, but just some other things. Mindset's really important. It's something you really got to practice, beyond VCE. Ricky and I are still learning, in our uni degrees about getting a good mindset and how to control your nerves and things. I remember in the legal exam, I was almost shaking. I was so nervous, but sort of about what I would probably tell my past self is that to not put too much pressure on yourself. You're all working so hard, and VC is a really stressful time, especially what you've all been with lockdowns and COVID and stuff. So be really kind to yourself, that you just try your best and, put in as much work as you can, but that's sort of the best you can do. You know, everyone is going to be different and learn in different ways. So be kind to yourself, just work as hard as you can, but just keep practicing and it'll be worth it once you're done as well. That'd be my advice. Planning can help, so making to-do lists, whether it's like between now and the exam you've got a to-do list, and then you've got one just for this week or just today. You know, you want to go to the Skyline revision lecture, then you want to go through your criminal law notes or something like that, so you can just keep yourself on track. And it's also really nice ticking stuff off, and you can sort of be proud of what you've done as well. That will help with mindset as well. Avoid cramming, so having those to-do lists will really help avoid that sort of last minute stress about everything. Go into the exam with a plan. So like I said before, like Raquel and I said, start off with the easy questions so you get them done. You might want to start with the bigger questions. You might just want to go start to finish. Doesn't really matter. There's no right way to do it. But do have a look through the VCAR exams if you haven't already on their website, just to see, you know, if this was my exam, what would I start with? What would I do? That will really help you. Like I've said here, always include examples from scenarios in section B. That's a really easy way to lose marks if you don't talk about them. So always make sure you do that, even if it's just mentioning the name of a person in a case or something, just to get that mark. And always look at task words. So look at some examples. But for example, if it asks you to identify, you just have to say what it is. So identify an error, just say what the error is, move on. If it asks you to evaluate, you've got to do strengths and weaknesses and have an argument. If it asks you to distinguish, you have to have differences in the content. So task words are a really good way to sort of maximize your marks, and it will really help you. Raquel, any other like exam tips for legal or just in general as well?
I think I just want to mention that there are a lot of questions on Mentee. So if you don't get to answer all of them, we will do a recording, a video, and we will put it on Mentee as well. So as well as having access to this video, you'll also have access to the other video that we're going to be doing. So go on Mentee and check that out. And in terms of advice for legal, I think there's certain constitution parts that you need to know. For example, section 109, section 7, and section 24. Make sure that you've got those covered and that you know the most important content, and you also have the pros and cons for them and some cases. You don't have to remember a whole heap of cases, but it will be important to have some there.
Yeah, awesome. Thanks, Raquel. And yeah, we'll do our best to get through as many questions as we can, but yeah, that will be helpful. We'll answer the rest of them in another video. Okay, just quickly before we look at some questions, exam report advice, really important that you read through them all from 2018 onwards. So we don't have time to go through all of them, but things like make sure you don't prepare answers, don't memorize them, just learn your content and be really flexible with what the question's asking, that you can sort of mold it to any question. Using stimulus material, really practicing your synthesis and application. So looking at those section B source material questions and trying to answer them to the best of your ability as well. All right, let's have a look at maybe one or two practice questions. For the ones we don't get through, I've included all the sort of sample answers in here, or they're also in the exam report. So exam report's a really good way to have a look at the ways to sort of approach the question. So for this first one, so I'm just going to read out. John has been charged with an indictable offence. He has pleaded not guilty. The victims are worried about giving evidence at the upcoming trial, which is expected to last for 6 weeks. John's lawyer has recommended that John should apply to the court for a sentence indication and consider pleading guilty. Explain one reason why a sentence indication may not be appropriate in this case. So again, you would want to look at the task word to explain, which means you don't just want to give the reason, but you have to justify why. So that's really important to get full marks. So a comprehensive explanation. You also have to make sure you're talking about sentence indication. So understanding your content is really important. You know, what we talked about it's applying to the court to make sure you can request to say, if I pleaded guilty, what would my sentence be? So showing you understand what it is. You don't need a definition, but just within your answer, showing you understand it. And one reason why it may not be appropriate. So give that one reason and that's it. If you have 2 or 3 reasons, they won't read them. They'll only read the first one, which means you have the risk of not going into enough depth. So you can see here, it might seem like an easy question, but 26% of people got 0 marks. So you've got to be really careful and make sure you're using the case scenario and sort of applying the knowledge, what you know about sentence indications to try to get as many marks as you can. So I'm not really worried about the content here, but just sort of those things you need to be careful about in order to get full marks. And I've got a sample answer in there as well that you can read later once you've got the slides, if you would like to. I'm going to skip over this question, but you've got it there if you need it. I'm going to look at this one before we go back onto Mentimeter and look at some of your other questions. So this question here, the use of parliamentary committees and royal commissions serves a number of valuable purposes. Referring to one recent example of a recommendation for law reform, explain one strength and one weakness of either a parliamentary committee or royal commission in influencing a change in the law. So this is a bit of a tricky question because, or 6 marks, so it's almost an extended response. And it's just very wordy. So you've sort of really got to work your way through it to try to find like, what do they really want you to do? So for example, referring to one recent example of a recommendation for law reform, if it asks you to refer to something or it says in your answer, mention this, it just means, quickly reference it. You don't need to have your whole answer about that. So that might be a mistake that some people make, is that they have half their answer talking about the recommendation, but you really don't need to. Instead, that most of your marks are going to come from explaining this. So explain one strength and one weakness of a parliamentary committee or royal commission. So like I said, you only have to do one of them, but whatever one you've decided to learn, one strength and one weakness. So you might have your explanation of one strength and then link it to a successful recommendation for law reform. So that's just including it in your answer. And then you've got your weakness, and then that's it. So you don't actually need to spend that much time doing it. So, a lot of people did get in, the higher range of 4, 5, 6, but the average was only 2 out of 6. So you've got to be really careful about, well, what are they asking? They don't really want me to elaborate too much on the example, but really focus on the one strength and the one weakness. And remember, restrain yourself to one of each, because any extra ones, they're not going to give you extra marks for it. You don't sort of sadly don't get bonus points for having lots and lots of strengths and weaknesses if it's only asked for one, because you'll only get the marks for the one of each. So that's important to think about. Okay, and I've talked about all of that. And then there's a sample response from the exam report if you would like to read through it in your own time as well. So that's it sort of for exam advice and things about looking for task words. I hope that helps, but I want to spend the rest of the time on Mentimeter, because I know you guys have got a lot of questions that you want to ask. So let me come back on our questions. Okay, here we've got 24 questions. So I'll do my best in the next 8 minutes to answer as many of them as I can. But like Raquel said, we will make sure we get to all of them in a video as well. So this question, distinguish, analyze, evaluate the extent to which. How can we answer questions with these words in it? So that's a really good question. I was asked this because a lot of these are similar, but a lot of them are different as well. So I might just do them one at a time. So distinguish means to sort of compare two things. But with the differences, a compare, you can have like similarities and differences, but distinguish means only really differences. They don't want to know how they're the same. They want to know how they're different. So for example, if it was distinguished between summary and indictable offences, you would say summary offences are minor criminal offences, whereas indictable offences are more serious criminal offences. So using that comparative word whereas will really like show the differences. So summary offences are in the Summary Offences Act, whereas indictable offences are in the Crimes Act 1958. So those sort of things to show the differences. That's what they really want to see in distinguish. And then analyze and evaluate are similar. They want you to go really in depth, but also have an argument and give strengths and weaknesses. So don't do all strengths or all weaknesses, but make sure you've got a bit of a balance. And then the extent to which questions are often sort of with, evaluate the extent to which, where you sort of say, I think petitions are effective to a large extent. So it doesn't really matter what extent you pick, but say something like to a large extent or moderate or only to an extent, or you might disagree, say it doesn't achieve it or they're not effective, as long as your strengths and weaknesses match. So if you're going to say petitions are effective to a large extent, you would want nearly all strengths, right? You would want lots of strengths to say they are effective to a large extent, and then just a few weaknesses at the end. If you're going to say they're not effective to a large extent, you would want mainly weaknesses as well. So it doesn't really matter which extent you pick. It depends on the question, but as long as you try to have that balance in matching your argument. So that's my advice for those task words. Raquel, anything to add to these task words?
I think you've got it great, but also just to echo what Molly said, if it's to an extent or evaluate or something, you get a mark just by saying to a certain extent. So it's easy marks to get. Make sure you do that, because I know a lot of students forget to do that. And also when it's analyze, evaluate, make sure you have a pros and cons, because that's where a lot of points are too.
Awesome. Great. Thanks, Rakaya. All right. How many examples case studies should we know? That's a good question. I would recommend go back through the study design and see where they ask you to learn them. So things like in criminal and civil law, you have to know your reforms. It says you have to know recommended and recent reforms. So there you have to know them. So that would be when you've got a recent and recommended for each factor in each area study, that ends up being 12 reforms, which is quite a lot. But if you can't do that, just do as many as you can. Like, you know, you're not going to need all 12 of them in the exam. It's just to be prepared for whatever they ask you. But to do your best with that, you have to learn all those high court cases, or like the example referendums I told you. So the studies don't ask you to do that. So I don't have a specific number for you, but start with learning all those ones you have to know that the study design says, and then anything else is just a bonus. It's just a good extra. You know, the Marlborough case you don't have to learn, but it's like I've used it today. It can be helpful for you to understand the content. So anything other than what's in the study design is just extra stuff to help you understand. Would you recommend to use the slides as notes for studying the exam? Yeah, definitely. Like if you're in the content process of relearning content, I've tried to make them, I've covered every dot point, but also tried to keep it concise. So it might be a good way that you can really focus on what's the important stuff. An exam, there might be stuff like, for example, with parliamentary committees that you might have to go do your own research, but hopefully a good starting point. And we've tried to make them as helpful as we can for you to use in your learning. So yes, I would recommend using the slides in the content stuff and then get into practice questions while you can. So you'll have these slides, like Rakaya said, that you can use them as much as you'd like in your revision. How many practice exams do you recommend completing? Really up to you. Everyone's different. Like, for example, I don't remember how many I did for legal, but I did two of the other subjects I did further maths and I did history revolutions, and I did better in history revolutions, but I only did 2 practice exams. But in maths, I think I did about 20 by the end of the year or something like that. So like that's just because that's how I learned the best in maths. Whereas for history, I really had to learn a lot of my content and dates and stuff. So legal might be, maybe as a starting recommendation, at least try to do all the VCAR exams. So that will be 4 all up with the sample 2018, 19 and 2020. Just be careful. Remember, the 2020 exam doesn't have high court case questions on it. So just be wary of that. But 4 is a good starting point, maybe. And if you can't do that, that's fine. Like I said, with history, I only did 2. So at least 1. And if you don't get time to practice exams, at least look through them so you sort of know what to expect with the structure. But Rakaya, do you have any other advice or experiences with like how many?
Yeah, I personally did 6, and the reason why is I struggled applying the content to the question. I knew all the content very well, but applying it is something else. So the way you apply for it is you have the content and you just kind of explain it, how it affects the content. So that's what you need to know. If you need to do 20, do 20. If you need to do 1, do 1, as long as you know how to apply the content too.
Yeah. Awesome. Thanks, Rakaya. All right, I reckon we've got time for 1 or 2 before we finish. So, okay, for the precedent terms, do they go under courts and lawmaking or fact? Oh, that's a really good question. So these terms come under the role of the courts in lawmaking. I think it's like of Victorian courts and high courts. That's the technical dot point. So that's just you learning what is the doctrine of precedent, how does it work, and then doctrine of precedent comes up again in the ability of courts to make law. But in there, that relates to more strengths and weaknesses of the doctrine of precedent. So it's flexible, it's consistent, all of those sort of things instead. But by the time you get to the exam, I know for your SACs, it's sort of very strict about this is what you learn for this SAC and this dot point. But in the exam, like I had an 8-mark question talking about law reform and civil law. So they really blur everything. So it doesn't matter too much. If you get a question about the effectiveness of the court to making law, you can still use those Latin terms if you think it helps your answer. So technically those terms come under the first dot point, role of the courts in lawmaking, but feel free to combine them together if that helps you in your answer. All right, let's do 1 more. So is it better to jump into practice exams without prior revision? Yeah, my advice would be little bit of content revision, even if it's just skimming the surface. Maybe today was your content revision. Maybe that's all you need to do is just have that have us tell you the content, a bit of revision, and then you might from tomorrow jump into exams. But some people will need more time to really get a grasp on some of the knowledge. So it really depends on you. I would say a little bit of content just so you understand the basics, then as many questions as you can. But like Rakaya said, she sort of needed practice exams to try to apply content and stuff. So if you feel like it helps jumping straight into exams, that might be helpful for you, but you might need your notes by your side to like help you fill in any gaps of anything you can't really remember. Yeah, I'll leave that as our last question, but any other advice on that, Rakaya? I think that's sort of it.
Yeah, I completely agree with you, because throughout the year I knew the content. So what helped me was the practice exams, and sometimes it helps to do one practice exam and see what you need to revise over. So if you need to do that, do it as well. But I think if you know all the content first of all and then learn how to apply it, that way it's easier.
Yeah, awesome. I'm going to mark that as answered, and we've still got another 18 questions to go. So we didn't get time for all the questions. Like Rakay said, we'll do our best to make that video so we can answer all of your questions. I'm sure a lot of them probably are asking similar things. So I hope that was helpful for you all. And thank you so much. We've still got almost 70 people here. So I'm so impressed about you've all stayed on with us and done a great job listening. I hope it has been helpful. You're feeling a bit more reassured. So you guys are doing really well. So just keep working hard. Give it your best shot, but we know you'll do well. So thanks so much, everyone. And you've got all those links and we'll give details about, how to get the slides and recordings and stuff. Otherwise, thanks so much for your time and have a great rest of your day. And like Kay said, we've still got more revision series, so psychology this afternoon and all the other ones. So it'll be great to see you there. But thanks so much, everyone. Bye.
Have a great day.
Bye.